All right. Very good. And welcome, everybody. This is the part 5 Little Hoover Commission hearing on the California Environmental Quality Act, Thursday, June 22nd of 2023. My name is Pedro Nava. I'm the chair of the Little Hoover Commission. Thank you all for joining us today. I want to introduce the other commissioners who are with us. We have Vice Chair Varner, Commissioner Dion Aroner, Bill Emerson, Gil Garcetti, Jose Atilio Hernandez, and Janice Sidley. Commissioners Beyer and Anthony Canella are joining remotely. We expect to be joined by a legislative member of our commission, Senator Scott Wilk, as the meeting progresses. Also with us is the commission staff, Executive Director Ethan Rarick, Deputy Executive Director Tamar Foster, Analyst Ashley Hurley, Allie Powell, and Sharon McAllister, as well as Project Manager Crystal Beckham. We have some housekeeping, as we've all become accustomed to when we do some things remotely. Some of the witnesses will testify in person, others will participate remotely. The video and audio of our remote witnesses will be turned on when they make their presentations. We will have a public comment session this afternoon. Members of the public attending the meeting in person may use the podium if they wish to make a public comment. Members attending remotely may also make public comment and should let us know they want to do so by using the raised hand function in Zoom. Those who make public comment remotely will be unmuted when they are called upon. Those who have joined us by phone may either dial #9 to raise their hand on Zoom or send an email to littlehoover@lhc.ca.gov, indicating you want to address the commission. You must provide the phone number from which you have joined the meeting so that our staff knows who to unmute. As is usual at commission hearings, public comment is limited to 3 minutes per speaker. So the total comment period will be 30 minutes. We are recording today's hearing, and after the hearing, staff will place a permanent link to the recording on our website to upload it to our YouTube channel. And now to the substance of today's hearing. This is the 5th in a series of commission hearings examining the California Environmental Quality Act, or CEQA. Since its creation in 1970, CEQA has been California's premier piece of environmental legislation. It has also, however, long been at the center of debate and controversy. Our first hearing provided some general framing with respect to the debates over CEQA. We heard from academic, policy, and legal experts regarding CEQA's impact, including both critics and defenders of the law. These witnesses offered different perspectives on some of the key questions in the CEQA debate. They also provided contrasting evidence regarding CEQA's effects. At our second hearing, we heard from 3 CEQA practitioners with extensive experience in CEQA, and again, with different viewpoints on CEQA and CEQA success. These witnesses discussed how CEQA works and shared their perspectives on CEQA and the current state of the CEQA process. They also discussed whether there are aspects of CEQA that they think could be improved and what changes, if any, they would like to see. At the third hearing, we heard from organizations that represent California's local governments. The fourth hearing featured testimony from organized labor. Today's hearing will focus on the role of the judiciary in CEQA, on challenges that CEQA cases may pose for judges, and on potential CEQA reforms that would impact the judiciary. This hearing is part of a commission study designed to explore the debate that surrounds CEQA, examine CEQA's role in protecting the environment, and evaluate CEQA's impact. I want to thank Commissioners Sidley and Aroner for serving on the subcommittee for this study and for their leadership on this crucial topic. So now I'd like to ask Executive Director Ethan Rarick to introduce our first witness. And before you do that, as a caution to our witnesses, both in the room and remotely, you may find that at some point during your presentation, you are interrupted. Now, in spite of all the lessons that we learned growing up, in this case, being interrupted is a good thing because it means that you have prompted a question or a response from some of the commissioners based on what they have heard you say so far, along with any written material or information that you have submitted. So I would respectfully advise you that you may hear from me and I would say, excuse me, please, but apparently I have a commissioner who has a question for you. So take no offense. It actually means that they're paying very close attention to what it is that you're providing. And with that, I will then turn it to Ethan.
Thank you very much, Mr. Chairman. Our first witness today is Whitman F. Manley. Mr. Manley retired in May of 2023, just a month ago. Happy retirement. Following a 35-year career as a California attorney focusing on environmental law. He spent the majority of his career at Remy Manley, an environmental law firm located in Sacramento. His practice focused on CEQA, the California Planning and Zoning Law, and other state and federal environmental and land use laws. His clients included public agencies and developers, which he represented in administrative proceedings and at trial and at the appellate level. He is a graduate of the University of California at Berkeley and received his law degree from Cornell Law School. Mr. Manley.
Interject with your own. Let me begin then.
Mr. Manley, is your green light on the, okay, all right. Yeah, maybe a little closer to you if you don't mind.
And go.
Thank you. Mr. Manley, before you begin, let me interrupt you. Thank you. You and I have never met. I read and reread your very carefully worded document that I guess is going to be part of, or maybe all of your testimony. What I'd like to know right at the beginning, are you speaking as an advocate for one side or another? When you wrote this, were you speaking for an advocate? When you look back on what you wrote, did it come across the way you want in terms of being an advocate or being as impartial as you could?
Really good.
We can't hear anything.
How
about now?
The
I
light
can
just
hear
got
it.
brighter.
I
Commissioner
can't hear
Canale,
the witness.
Can you now hear the witness?
How about now?
Someone that just said, "How about now?" I can't tell who's talking.
Yes.
So.
That
Okay,
was me.
that
Okay,
that
yes,
was
I
that
can
was
hear
Mr. Manley. So
I can
you
hear.
can, okay, sorry, we had his mic off. So please continue, Mr. Manley.
Bottom line is an advocate for my perspective, not for a particular client, but my perspective is influenced by the clients I've had over 35 years. I don't deny it. I will say I'm not hostile to CEQA. I think it is a statute that has had enormous and continues to have enormous benefits. It's all about balancing them against the undeniable costs. And that's not an easy balance to strike. I'll be the first one to admit it. But there are frustrating things about the statute that probably came through in my letter.
Good.
Is that helpful?
Yes, thank you.
Okay. I'm going to talk just about two things. I could probably drone on, as my initial dialogue suggested, for a very long time about CEQA. I'm not going to do that. I'm going to focus on the statutes that have qualified certain projects for expedited judicial review, because I've had some personal experience with those. And then I'm going to talk about judicial education. If you have questions about other issues, I'd be happy to address them, but time is short, so I'll focus on those two. First of all, with respect to the statutes governing expedited judicial review, there are statutes that have been on the books for years that have required that CEQA cases be given priority. And if those statutes are followed, then generally speaking, a CEQA case should be resolved by the trial and appellate court in about 2 years. Those requirements are honored in the breach every day. 2 years is a prompt time to handle a CEQA case amidst all the other things that are going on at the trial and appellate courts. So 2 years is something that they're supposed to aspire to, but it's not typically met. In my own experience, I've handled a lot of cases up through appellate court opinion, and typically they take anywhere from, at the short end, as little as 18 months. My last case actually was resolved in about 18 months. It was remarkably quick, up to 6 years. And that is a very long time to have a case pending. and be unable to access construction financing for a project that has been approved. You're just simply stalled out functionally for as much as 6 years. And that does impose costs, and it's enormously frustrating. I think the legislative response has been to designate certain projects to qualify for expedited judicial review, 270 days, quote, if feasible. I've been involved in 3 such cases, and one of them did not get litigated, 2 did. The 2 that did, neither of them were resolved within 270 days, but there were specific reasons for that. The courts clearly made them a priority. They were both resolved in under 290 days. So that is remarkably fast. Now, those are very specialized, narrow classes of projects by legislation. The 2 that I was involved in that went to trial, they both happened to involve very large sports facilities, which is some of the classes of projects that have been designated for getting certified for expedited judicial review. What is it about 270 days? Why not some other number? Well, candidly, I didn't write the legislation, but I know the lawyers that were involved in it, and they sat down and figured out what is the shortest amount of time that one could jump through the procedural steps and get to a court of appeal opinion. Does it have to be 270 days? No, it could be 300 or 365 or 18 months. To me, the issue is broadening the class of projects that get handled in an expedited way, because for every basketball arena, there are 100 other projects that draw CEQA challenges that are subject to priority, but that might take 3 or 4 or 5 years to wind their way through the courts. Yes.
So my question to you is, as you're talking about expanding and broadening that view, is there a different path other than just making everybody special? Is there another path that you might think of to change CEQA a little bit so that everybody's on the same playing field, where everybody, pardon the pun as we're talking about sports facilities, but where everybody is equal and can get through the process in a theoretically expedited manner?
Well, there is one idea that's been floated that you're actually going to hear about later this morning, and that's a specialized CEQA court, which would compress the trial and appellate processes into one. First of all, and second of all, you'd have a court that would actually be dedicated to CEQA and land use disputes. They would develop expertise. They could be subject to some time limit. Does it have to be 270 days? No, it could be longer than that. And it's something that would remove an existing load from the judiciary and place it in the hands of folks that would necessarily develop expertise. So it's also related to the judicial specialization issue that I'll be talking about too. So that's one idea. I think an interesting one.
Commissioner Byer apparently also has raised his hand. He's not here. He's on Zoom.
Yeah, thank you, Mr. Chairman. I appreciate the witness's background and expertise. I want to predicate the question on taking a step back and going to perhaps a higher altitude than CEQA in particular. First, a literary reference. Charles Dickens in the 19th century talked in Bleak House about Jardyce versus Jardyce. It took 24 years for that case. Clearly, the judicial system has dealt with complicated cases that have been the subject of delays. And the federal courts and all the state courts have created mechanisms to deal with that complexity, whether it's multi-district court litigation, chancery court in Delaware for complex corporate cases. So if you could try and answer the question, is there something inherently true about CEQA that is not true about other complicated cases involving cutting edge technology and patent litigation or complex corporate litigation, mass torts or something like that? Because the problem that we're facing about delay doesn't seem to be new or just based on CEQA.
I'm not an expert in patent litigation or mass torts, and I really can't speak to those areas of the law. I can speak to CEQA. They do involve a measure of complexity. There may be other areas of the law that involve equal or even greater complexity, and the courts ought to wrestle with those as well. But that doesn't change the fact that there is CEQA is an active area of the law. There's no question that large projects tend to get litigated, and they tend to involve complex policy and technical issues and impose significant burdens on the judge or justices who were assigned to handle them. That's just simply the nature of the beast. They raise questions of law resolved by the courts, by the judge, by the justice, against the backdrop of an administrative record that may span well over 100,000 pages. And they need to address each and every issue raised by the litigants, which could be 10 issues, 20 issues, some of which could be highly complex. I do cite one example in my letter of the evolution of our understanding scientifically and on a policy level with greenhouse gas emissions and climate change. That is a deeply complex issue. And yet it's one that the courts have to address because petitioners raise it and agencies respond to it, and it gets litigated. That's just simply the nature of the beast. So the fact that there are other areas that are complex, I don't deny it. I'm trying to focus on trying to make CEQA a bit more efficient and predictable.
Thank you.
Vice Chair Varner. Vice Chair Varner has a question.
Thank you, Mr. Manley, for being here today. Given the likelihood of the Judicial Council approving a specialized court for CEQA, do you have, and following up on Commissioner Sidley, do you have a recommendation or a thought on how to prioritize certain cases that you believe, you talked a little bit about the sports arenas that get a hierarchy. Do you have a recommendation of, absent a specialized court, how we could prioritize certain cases that would need to be expedited as opposed to others?
I would hesitate to, obviously right now we have expedited judicial review for narrow classes of projects identified in legislation. That leaves the vast majority of CEQA cases behind. It doesn't apply to them. To me, I would regard any CEQA case as one that ought to be entitled to greater level of priority than it has been historically. I will say that usually most of the delay associated with CEQA cases occurs at the courts of appeal, not at the trial courts. The biggest delay in trial courts is the preparation certification of the agency's record. We've heard testimony actually from both sides of the debate, thinking about ways in which record preparation might be expedited. And I think it's great that folks want to focus on that. And that will help, certainly at the trial courts. The courts of appeal, the case is fully briefed, and sometimes it's set for argument shortly thereafter, and sometimes it's set for argument a couple of years thereafter. I'd like to see that a bit more standardized because it is deeply frustrating to just have a case sit there.
Yeah, I see Commissioner Garcetti and followed by Commissioner Hernandez.
A couple of questions, if I might. I spent my legal career in the Los Angeles County District Attorney's Office, 32 years. And one of the first things I noticed in my first few months in the District Attorney's Office, going throughout the county, was how much judges hated domestic violence cases. They couldn't get rid of them fast enough. Forget the consequences of that. That went on and on for years. Fast forward to when I became the district attorney, and I started pushing one thing, many things, but one thing regarding domestic violence. One that, first of all, only the lawyers in our office who've been specially trained and dedicated, they will handle the case from beginning to end, not separate prosecutors coming in. With the judges, I was concerned about what kind of background education did they have to handle domestic violence case. And the Los Angeles County Superior Court was very reluctant to get involved in any special training. And I hit hard on this until finally they agreed to do it. And then they went a step further at my request. They said, maybe you have specialized domestic violence courts so that the judges who handle the cases are judges who are interested in the subject matter and have special training. That raised the issue, do we have enough judges to do this? So it's the same issue here. that I see. And you're going to talk about the training that the judges have, but are these judges who wanted this training? Or they're the low person on totem pole in terms of, okay, you're the new guy on the bench. You're going to be handling these cases. What? I know nothing about it. You will. You'll learn. Number two, what if there were additional resources? I'm talking about judicial officers and staff to handle these cases.
They're all eager to seize. No, actually, it's not necessarily true. It varies, judicial approach towards CEQA, whether they're enthusiastic about the cases or dread them, varies. I will say they take a lot of work. Whoever gets assigned a CEQA case, the record shows up. It used to be in banker boxes. Now perhaps it's on a thumb drive, but it is a lot of documents and a lot of issues will be raised, and some of them will be quite technical and complicated. And the quality of the lawyering is going to vary. So they do require a lot of judicial resources. I have had some judges tell me that they like CEQA cases. They find them fascinating. That's one reason why I got into this.
You almost sound surprised.
I found them fascinating. They're about what the landscape should look like, what our interrelationship should be to that landscape, and what policy decisions should be made. And they do raise the whole panoply of environmental issues, biology, transportation, greenhouse gas emissions, air quality, et cetera, et cetera. So they are intrinsically, it can be quite fascinating. And some judges really do embrace that. And others probably feel like it's a bit of a slog. The courses that we have, that I've been involved in, which started in about 1999, were developed by the Judicial Council through their education branch, and they are voluntary. They're not mandatory. I don't know how much elbowing happens behind the scenes to get people to sign up, but they are voluntary. I will say they're always fully subscribed. They always have waiting lists. So there is interest in folks to try to get their arms around this whole amorphous beast called CEQA. I hesitate to say that they should be mandatory. I could certainly see devoting additional resources to them. Most of the work in the time I've been involved for 22, 23 years, it's done on a volunteer basis by practitioners. There is a significant effort to make the classes balanced. All three perspectives in the CEQA process are represented. I've been sort of the designated developer lawyer. As Susan Brandt-Hawley has typically represented the petitioners groups, and Margaret Sohagi has represented agencies, with some pinch hitters due to scheduling conflicts, that sort of a thing. And we prepare the materials and circulate them amongst ourselves to try and achieve neutrality. Actually, I will say one aspect of the courses, and one reason why I think we've received good reviews, is that because these various perspectives are represented, and because the CEQA case law does not represent a uniform fabric of consistency, we do have debates, we do disagree. Sometimes we have those disagreements right in front of the research attorneys, judges, and justices. We are collegial. So it's not just like a courtroom of people battling with one another, but we have a dialogue where we agree and disagree. And Justice Roby, who presides over these courses, is a very able moderator to keep us in line. So I think those courses have been helpful. Could they be better? Could more resources be devoted to that effort? Surely. I don't pretend, it's very difficult to fit this effort amidst one's other's obligations as just a practicing lawyer to make this volunteer effort. And I've been happy to do it. I've been honored to do it. But it would be great if there were staff resources available to help prepare the materials. Your staff report noted that the Judicial Council put some work into developing a bench book on CEQA to help judges get acquainted with the statute, and they had resource issues. They weren't able to follow through on that effort. That's not a bad idea. I would welcome that. If there are other ideas about how to restructure the course, expand the offerings, those are all worth talking about.
Quick question on that. It's my understanding, but you'll know firsthand that the courses are offered like once every 2 years. I love that they're oversubscribed, but I think that maybe candidly, somebody's want to go and it's full, or they have a conflict. But is that correct that they're not offered? It's not 4 courses a year that people can sign up. What is the availability of the course?
They've typically been offered, it's a 2-day course, and it's kind of a soup to nuts introduction to CEQA with a focus on the court's role. And it's offered every other year.
Yeah, every other year.
We also have done shorter CEQA update type courses that are specifically designed for folks that are already acquainted with the statute, focusing on particular topics that have been very active in the courts. So the last one we did a few months ago had a segment on housing, because the legislature and courts to some extent have been very, very active in that area. And we just wanted to share with them what the legislation says and how it might find its way to the courts.
I think as we all hear more about the complexity of this law, maybe every other year is not sufficient for the bench, but just a thought.
Commissioner Hernandez?
Good morning. Quick question. You mentioned both in the written testimony and right now in terms of there's already something in the books about granting preferential treatment for CEQA.
Mhm.
And then you said that it's whether or not the courts decide to adhere to the requirements. So a question I have is on oversight in terms of, I mean, are these strict requirements to the courts, or the courts have lots of leeway? Related to that, I mean, every time we have the expedited 270 days, who's overseeing making sure that the courts are adhering to that as well?
The requirement that there are a variety of procedural requirements that apply at the trial court that are designed to keep the litigation moving. And generally speaking, with the exception of record preparation, which can bog things down, those mechanisms seem to work pretty well. So a typical CEQA lawsuit, if it's a big record, it might take longer, but a typical CEQA case will get resolved within a year, perhaps 14, 16 months, and you'll get a trial court judgment. So I think those mechanisms work pretty well across the state. We also have designated CEQA judges who, in larger counties, that develop expertise. So for example, in Los Angeles County, there are 4 designated CEQA judges, and they are all very experienced because they handle a lot of cases. Appeal, it's direct. It's couched in language that isn't mandatory. It's directive, and it frequently is not observed. Appeals are supposed to be resolved within a year, and more often than not, they are not resolved within a year. Could you make that language mandatory? Well, you know, I do understand, certainly we've heard this from the judiciary in connection with the laws governing expedited judicial review. They're concerned, I think justly, about crowding out other cases. What makes CEQA special such that we're not going to get to the cases on our docket dealing with other particular issues? And I understand that, and I also understand their desire for additional resources. Those are natural concerns for the judiciary to raise. I'm just looking at it from the perspective of my clients and being bogged down in litigation after having worked very, very hard to work your way through the administrative process. Your second question was, I don't want to.
In terms of the mandate for the 270-day or sometimes expedited, is it working, the oversight aspect of it?
Right. The 270 days, it's up to the courts to attempt to adhere to 270 days if feasible. And in the cases I've handled, they have not adhered to the 270 days, but they have come very close. The reasons they did not adhere to it were due to some procedural machinations that occurred along the way. To me, it's clear that there was a good faith effort by the judiciary to just bust it and get as close to 270 days as possible. No question.
Let me ask Mr. Manley, I don't want to cut you short, but we do have 4 other witnesses for the morning session. And so if you have additional aspects of your presentation.
I will just say one other thing. This is a little bit off the topic, but I have to respond to some testimony that you received that suggests that there aren't areas where CEQA case law is inconsistent, that it is more predictable than, in my view, it actually is. One of the frustrations associated with being a CEQA litigator is the fact that we've had decades of CEQA case law of courts issuing published opinions. And over the course of all those opinions, you can find a case for virtually any proposition, and lawyers will find it and argue it to the judge, and they will seem to point in opposite directions. And then it becomes up to the court to decide which line of authority to follow. Well, that makes it very, very difficult to predict. In fact, my confidence has diminished over time in predicting what a court is going to do with a given record in front of them. And that's one thing that attracts me to this idea of a specialized CEQA court, because presumably if you have all these cases handled by a single body, there might be some greater consistency over the course of time. There are a lot of areas in which the courts seem to be somewhat, well, there's tension amongst the published decisions. Just very recently, there were a couple of decisions that have come out that have held that EIRs were inadequate for not looking at a particular alternative to the project under review. One aspect of an EIR is that you have to look at a reasonable range of alternatives. And generally speaking, up until very recently, the courts have been fairly deferential about how an agency goes about doing that in an EIR. And just in the last year, we've had 2 published decisions that say, yes, but you didn't look at this one and you should have, and therefore your EIR was inadequate. Those cases are going to be cited in attacks on EIRs. What will a reviewing court think 4 years from now about whether I had enough alternatives in my EIR? I was more confident in that answer a year ago than I am now. That's a frustrating place to be. There are many other examples. Courts historically have been deferential to the way the environmental impact report describes the existing physical environment, because that's a factual issue. There are cases suggesting that perhaps deference is unwarranted and that the description of the environmental setting in a given EIR was inadequate as a matter of law. Again, no deference to the agency. So what's the rule? There are many other examples I could provide like that, where there are tensions. And I will say, part of that is just simply because it's a complicated statute. A given physical issue comes up, environmental issue comes up, policy issue comes up. CEQA consumes that issue and makes it its own. Now that becomes an issue that needs to be analyzed in an EIR. We didn't analyze GHG emissions and climate change 30 years ago. We do now. We didn't analyze wildland fire and evacuation 10 years ago. We do now. CEQA will make that issue its own. And frequently those issues as they arise are just inherently difficult.
Great.
I just want to add that it's to the last point of the inconsistency of the courts or the changing, is that each change, just the reality of it, increases the cost and the time. So I think it's important, as we're talking about the judicial piece of this and whether or not we speed up the judicial piece of it, to not lose sight of the fact that there's an upfront timeline as well. The NOP, the doing of the research, doing of the analysis before you even get to that point. So I just think it's important for all of us as we work through this discussion to remember how long the whole process is, and then you get to the decision, and then you add 100 or 270 days or 300 days or 6 years or whatever. So you've already spent a lot of time. And to what Mr. Manley said, you're trying to get financing, you're trying to do all those things that add to the complexity of whatever project is going through this process. So I just wanted to add that, because I think you have to look at it holistically, not just at the judicial piece, to really understand the whole complexity of it. So thank you. I didn't mean to jump in on your point, but I just wanted to add that.
Thank you for your testimony.
Thank you.
Ethan, if we could have the next witness, please. Thanks.
Thank you, Mr. Chairman. Before I introduce the next witness, I might mention for people in the room who came in after the meeting started, if you wish to make public comment later today, and there will be a public comment session, there are some forms at the table by the back, where you came into the room. If you can fill those out, give us your name. We actually don't need everything, but if you can give us your name and bring those up to the staff at the front table there, we will get you on the list to make public comment. So bring those to us. Mr. Chairman, I'll now introduce the second witness who will be testifying remotely. And the last comment by Mr. Manley actually leads into this testimony because Mr. Tangri will be talking about the evolution of CEQA through case law. Shiraz Tangri is a principal in the land use, environmental, transportation, and infrastructure practice groups at Meyers Nave. He focuses his practice, on development of infrastructure, transportation, and real estate projects. He has deep experience in CEQA, in the National Environmental Policy Act, NEPA, and in complex litigation involving many environmental issues. He holds a bachelor's from New York University and his law degree from Georgetown University. With that, Mr. Tangri, please go ahead and make your presentation.
Thank you, Commissioners. Are you able to hear me okay?
We can.
Great. Thank you for the opportunity to address you today. I appreciate it. As mentioned, I am a CEQA practitioner. I've been working on CEQA compliance issues and litigating CEQA cases for over 20 years. I certainly speak from my own personal standpoint and my own personal experience, not on behalf of any clients. But as acknowledged my background, the majority of our work is typically working on development projects, either representing the developers themselves. Sometimes those are public agencies, sometimes they're private concerns, and also the reviewing agencies. We have also occasionally been in the position of being a CEQA petitioner. Again, typically for either an agency or some other private entity that's concerned about a project. So we've been on sort of all three sides of the CEQA triangle, if you will. I'm going to address today the issue of judicial case law and how that interacts with CEQA. We tend to always refer to CEQA as a statute or the CEQA guidelines as they're implementing regulations, but in CEQA, far more than in other areas of environmental law, you're really called on to understand the ever-evolving case law to be able to give informed advice. And that happens right from the get-go. This isn't just once you're in litigation, what's happening in other courts. There's a lot of CEQA case law that dictates critical decision-making all through the compliance pathway, right from the initial get-go of deciding what form of CEQA process do we have to comply with? And I'm going to talk a little bit about that today. I will echo Mr. Manley's comment. I do believe that the evolution of case law has made things more confusing over time. There's not a tremendous amount of consistency. I'm actually going to talk today about a couple of decisions from the Cal Supreme Court. So that's an issue that's maybe not addressed by a CEQA-specific court or a CEQA-specialized appellate court. But I want the Commission to understand how these decisions, once they come out, really have a major effect on how CEQA is then applied by public agencies and by developers across the state. So I'm going to address three areas, two of which are related to standard of review. That's the level of scrutiny that the court applies when evaluating a public agency's CEQA compliance pathway. And then I also want to talk briefly about attorney's fees. So let me start with the standard of review. I know in prior meetings, the Commission has been advised about the three tiers of CEQA review or CEQA process. At the bottom level, you have projects that are exempt, or where there's an exclusion either by statute or some other regulatory method that a category or class of project does not have to go through CEQA review. So there's essentially no review conducted whatsoever. In the middle tier, you have what are called NDs or MNDs, negative declarations or mitigated negative declarations, which are intended to be more streamlined review when a project has no reasonable significant impact, or any significant impacts can be mitigated to less than significant. So that's sort of the middle tier. And then the top tier is the environmental impact report, or EIR, the full-blown review. And with each step, you essentially have additional levels of public scrutiny and public comment. So with an MND, you're talking about typically a 30-day public review, single public review period of about 30 days. And an MND preparation can take anywhere from sort of 3 months for a very accelerated one to roughly a year, sometimes more, in a more complicated situation. In EIR, typically, at lightning speed, you're looking at just under a year to prepare and get an EIR through the process. And in many instances, you're looking at a multi-year process just to get through the environmental review process. And as I think has been testified to in prior hearings, the CEQA process is often the most time-sensitive aspect, because until your CEQA process is complete, you can't get your public agency approvals until you've completed your CEQA review process, right? So your critical path for development goes through CEQA, and lots of other aspects, the other approvals you need are typically sort of coordinated, so everything happens at once. But you will hear from developers, the time element, the thing that costs them the most money and takes the most time is CEQA compliance. So standard of review. Let's start at the EIR level. For many years, the standard of review for an EIR, in terms of whether an EIR prepared and approved by an agency was adequate and adequately complied with CEQA, was a twofold standard. And procedural analysis, i.e., were public notices issued, was the time periods of public review complied with. Those types of purely legal requirements were given more detailed scrutiny by the courts. However, substantive decisions, those that involve facts and application of facts to a particular project, substantive decisions were supposed to be reviewed with significant deference to the public agency. And this goes back really to principles of separation of powers, right? You have the judicial branch reviewing decisions made by another public agency, and typically where you have an EIR approved, you're looking at a legislative or quasi-legislative action by that public agency. So you have the court saying, we're going to defer to those factual determinations that are made. Those agencies have the technical expertise. The California Supreme Court, as far back as 1990, in the Citizens of Goleta Valley case, essentially echoed this dual track and said, the wisdom of approving a development project, a delicate task which requires balancing of interests, is necessarily left to the sound discretion of local officials and their constituents. And that was the law of the land for many years. It was reiterated some years later. The 1995 Western States Petroleum case by the California Supreme Court reiterated that principle and acknowledged that separation of powers was what drove that deference to the agencies on substantive decisions. That has always provided a certain level of comfort to folks in the development process, where if an EIR is required or justified, they have a level of certainty that when they get to court, the judge isn't going to second guess the decisions that were made in preparing that EIR. And again, I think there's been testimony about this, but the preparation of an EIR is it's a complicated technical document at this point. You have experts that are retained to do things like your air quality analysis, health risk analysis, noise, biology issues. All these are done according to industry reviewed and approved standards that evolve over time. So the preparation of these documents is intensely technical. And an EIR, back in an earlier time frame, an EIR might have been a several 100-page document. Now, we're always working with agencies to try and make these things less than 1,000 pages, and then you've got appendices that are typically many thousands of pages more with all that technical background information. I see a hand up for a question. Should I keep going?
I'm
Mr.
sorry.
Chairman?
That
Yeah.
is Commissioner Byer. I
Okay,
believe.
Commissioner
I-
Byer.
I could not see that.
Sorry, thank you. I'm glad you caught that. Thank you.
Well, thank you to the witness for noticing. I want to take, again, the conversation to a slightly different perspective. If I understand you correctly, and I hope I do, it sounds like under previous California Supreme Court precedent, I think you cited the Western States Petroleum case, that there was something like in the federal system, deference to federal agencies, the so-called Chevron doctrine. And that provided a stability, but also undergirded a sense of democracy. That is, elected officials should make policy choices. Judges should not create them out of whole cloth using either common law or judicial activism to come up with results that they think are correct, and that there should be deference to the fact finding and technical expertise of agencies and elected officials. Is that a fair summary of what you just said?
It is, and I would just add, there's sort of two sides to that. One is the deference to sort of public policy, right? And that's that I think I mentioned the citizens of Goleta Valley case, actually even earlier than Western states, said, these are delicate balancing acts. CEQA is intended to be a disclosure statute. It's intended to engage the public and other agencies. But once those issues have been fully fleshed out in an EIR and there's been public comment, whether an agency decides to live with those environmental consequences or not, that is what public agencies are supposed to do. That is their domain. And so the judicial branch should not be second guessing that. The other side is that technical aspect, right? That judges are not in a position to go back and review the micro details of an air quality analysis and determine whether a model was correctly run or the inputs were correctly determined. So both of those essentially dictated a more deferential standard of review that is very consistent with the federal model. It's frankly consistent with many years of common law where there are limited circumstances in which the judiciary should be overturning a policy decision or a discretionary decision by a public agency.
So from your perspective, CEQA as a disclosure law has been successful in getting community input, but it was not an invitation to the judicial branch to make new law outside the context of passing new statutes at the state level or different views from elected officials who are issuing permits or making other governmental decisions. Is that a fair summary?
It is, although I think I would say this is necessarily about sort of making new law per se, more the way that the laws are applied and the rules that those set for folks that have to follow them, right? So as mentioned, CEQA practitioners are always on the hook for knowing the evolving case law. And so when you have a pronouncement from the Cal Supreme Court that says, well, we're now going to analyze a decision in a different way, that now has a trickle-down effect where everyone that's complying with CEQA has to analyze what that means for their particular project and the type of review that they're doing.
But if the legislature doesn't explicitly deal with greenhouse gases, which was referenced by another witness, the judicial branch is essentially invited to fill that vacuum with whatever their views are, as opposed to a legislative decision.
I actually litigated one of the first cases in which the greenhouse gas argument was raised, and it was before there were, this was more than 15 years ago. So the greenhouse gas was not an issue that was included in the list of topics that needed to be analyzed. The challenge was made, and essentially the trial courts there found, while this is an evolving area of law, there's not a mandate to study it. It was we won the battle but lost the war, so to speak, because of course we could all see that this was coming. And so now the guidelines have been evolved. So greenhouse gas is an area in which people have to, any analysis has to look at greenhouse gas impacts and climate change impacts. It's really a question of, is that the appropriate role for the courts to decide, when that's an issue that has to be studied, or given that CEQA is a statutory creation and has its own regulatory process, does the legislature or the implementing agencies get to determine when those changes are made, right, in terms of what CEQA is supposed to analyze?
Thank you.
Sure. So let me talk about the Cal Supreme Court decision. In 2018 on standard of review, this is a case that's often referred to as the Bryant Ranch decision. That was the project at issue, a 2,500 home, I think, senior living project in Fresno County. Fresno County prepared a full EIR. That EIR included detailed air quality analysis that looked at and fully disclosed the air emissions that would be emitted from the project, including ozone precursors. And despite all the sheer volume of information that was provided about the project, the Cal Supreme Court held that the air quality analysis was inadequate. And in so doing, it really kind of turned the standard of review on its head, because what it said is, well, we have the numbers here. You've disclosed, you've done the analysis, you've run the models, you've disclosed the actual emissions that are going to be generated, but you haven't explained what those numbers mean for the layperson reviewing this. So somebody who's potentially impacted in reviewing this document would not necessarily understand what those potential health impacts would be simply because you've disclosed the amount of air emissions. And the court found that that was a flaw in the disclosure aspect, and essentially concluded that a de novo standard of review, so a much less deferential standard of review. The court was essentially saying this is more of a legal issue and not a factual issue, and therefore we are not deferring to Fresno County's judgment in this because the EIR doesn't provide adequate disclosure of these air quality impacts. So,
Shiraz.
Mr. Tangri,
Yes.
let me interrupt Commissioner Sidley.
please.
Hi, Janice Sidley. I know our time is short with you and I do appreciate your testimony. I just sort of cutting to the chase here. Your experience, are the courts, in your view, stepping in where the legislature has left a void? Or are the courts are the courts becoming more activist? Have you seen it just in recent times? Are we seeing more CEQA decisions, more changes? Obviously, I think as we heard from Mr. Manley, things are changing, and then you have to go back and you have to study other things. Are you seeing that sort of historically, that there's that change as a broad view?
I think so. I think what you're seeing is, in greenhouse gas as an example. So as our environmental regulatory world becomes more complicated, all of that gets pulled into CEQA, and now you have courts trying to fill in the gaps. Now, I will say this particular issue, the standard review issue, that's been out there forever. And of course, courts have to apply that. But I raised this case because you have a situation now where for anyone preparing an EIR, you now have this extra layer of process as a result of this particular case, right? So you now have to not just go through your technical analyses, but now there's this extra step of this very subjective, are we now boiling that technical information down in a way that, it can be, we're fairly conveying the information that's there. That's a different standard than has been in place now for 30 years, right? And every public agency that's going through an EIR is trying to understand, how do we address this subjective standard? I think this is an outgrowth of how complicated CEQA has become. And I would also say, in terms of the judicial role, because there has been very limited revision or substantial overhaul of CEQA for many, many years, you get a little bit around the edges at particular times, but there's not a comprehensive overhaul, right, for many, many years. And I think that also allows greater room for courts to come up with these decisions. And again, when you're especially talking about a Cal Supreme Court decision or any appellate court decision, the effect of that, if they're changing the standard of review or something else that's significant, that applies across the board. And now every CEQA practitioner, every public agency has to make an adjustment to the way they do business to comply with CEQA.
So a change, I'm going to end, so because I know that you're watching the clock, but a change to a de novo review back to deference to a lead agency or something could be very helpful to people who are trying to figure out what to do and how to handle the changing world. Is that sort of what I'm hearing?
Actually, I sort of the other way around. When the Supreme Court imposed the de novo review, they were essentially applying the legal standard to substantive decisions, right? They were sort of flipping what the traditional standard had been, making EIRs, I think, a far less, or making the standard of how to comply when preparing an EIR far less clear, right? And the second standard review I was going to reference is the MND standard, i.e. the fair argument standard. That's another area where judicial opinions have really brought the bar down, the level of deference on an MND way down, to the point where for many, many years, and this has been the case for a long time, an MND has been almost a no-go zone for any project that has potential for controversy or where there are known challenges, because you get this lower standard of review. Essentially, it takes very little for a court to find that there was a fair argument that a project may create a significant impact, not will, not must, but may create a significant impact. So for a project of any size or scale, an M&D is off the table. And many projects, affordable housing projects, other projects where the margins are much slimmer, many public agency projects don't necessarily have the resources and the time to go through the full-blown preparation of EIR. So that's another instance where the legal standard really impacts what happens in the real world, because if a project thinks it's going to get challenged and it can't survive that challenge, it can't wait those 2 years to get through the litigation, they're not going to do their project. Their financing will have been long gone before then.
Thank you. Understood.
Thank you. Let me respectfully suggest you take 2 more minutes and wrap up your presentation, because I do want to make sure that the other 3 witnesses have an opportunity.
Thank you. So the last point I'll make is the attorney fee point. And this is actually not a piece of CEQA, meaning this is a statute. The rule comes in the Code of Civil Procedure. It applies more broadly than CEQA, but in CEQA cases in particular, the 1021.5 private attorney general rule is pretty routinely requested or identified by CEQA petitioners as a basis for seeking attorney's fees. As a practical matter, again, the courts have, and this mostly happens in the trial court, but it's been affirmed in the courts of appeal. Virtually any CEQA petitioner that prevails in a CEQA case will recover their attorney's fees under the private attorney general statute. The statute is really intended to cover litigation that is in the public interest and that delivers a benefit to the public that's out of proportion with the plaintiff's own stake in the project. But as a practical matter, if a neighbor or an opponent challenges a project and gets it struck down, there is case law that says, well, enforcing CEQA is itself a valuable public good. Forcing a public agency to go through and comply with CEQA is itself a public good. And so on that basis, we're going to award fees. So what's resulted over time, and that's been the case again for decades. So over time, what's happened is any CEQA plaintiff that's going to prevail will have a fee demand. By contrast, if a public agency prevails and defends their project or the developer, there's no authorization to recover fees, right? So you have it's a very one-sided rule the way it's been enforced through the courts, and that's the case even if, for example, the project at issue has tremendous public value, right? There's many things that public agencies do that serve hundreds, thousands, potentially millions of people, because that's what public agencies are supposed to do. Their projects are intended to serve the public broadly. Nonetheless, defending an important project does not entitle an agency to fees. An agency will have to find the resources to defend that litigation. And same is true whether you're talking about a private project that's funded by a private developer or something the agency is doing on its own dime, essentially on its own general fund.
Thank
That
you.
would pause for any other questions.
Thank you very much. Let me, no. All right. I want to thank you for your testimony, and I apologize. I've got to move the train along the track. So if you'd be so kind, Ethan, for the next witness. Thank you for your testimony.
Thank you very much, Mr. Chairman, and thank you, Mr. Tangri. Commissioners, the next two witnesses will address specifically the issue of a specialized CEQA court, coming at it from very different perspectives. The first witness who is here in the room with us is James G. Moose. Mr. Moose is a senior partner at Remy Moose Manley, the firm from which Mr. Manley recently retired, where he has practiced for over 36 years with a focus on advising public and private clients with respect to issues raised under CEQA. He advises clients both during public agencies' administrative processes and in litigation, has been involved in numerous lawsuits, and has drafted amendments to CEQA and the CEQA guidelines. He holds, Commissioner Sidley would be glad to know he holds both a JD and a BA from the University of California at Berkeley.
Double bear.
And he wrote a letter, as commissioners know, to the commission advocating the creation of a specialized CEQA court. That letter, for commissioners' references, begins on page 63 of the packet for this meeting. With that, Mr. Moose.
Thank you very much. I appreciate the opportunity to speak to you. Being that I'm the last in-person witness, I claimed the one bottle of water up here on the theory that no one else here would be needing it. So hope that was okay. I am an advocate of a specialized court. This is a recommendation I reached entirely on my own, just based on being a CEQA lawyer for a very long time. In anticipation, Commissioner Garcetti, of a question you might ask me, similar to what you asked my very good friend, Mr. Manley. I am here on my own behalf. I do have clients, unlike Whit. I still have a lot of clients. I haven't really spoken to any of them I can think about on this topic. And one thing I've been able to get away with for a very long time is that because I'm one of the older partners in a small firm, I tend to say in public what I think, hoping that I don't lose clients. And I'm 64 years old now, and I've been busy the whole time. So I haven't paid too much of a price for that. Maybe there are people who never approached me, having heard what I said in public, but I do speak my own mind. And I would say that right now, I think the audience whose esteem I care the most about is my 30-year-old daughter, Julia, who is a environmental consultant with a focus on climate change. And she will give me a hard time if I say anything that doesn't represent what she regards as the highest ethical standards. So by way of background, my own philosophy about environmental regulation and land use and CEQA is that I am a champion of the statute. I like the fundamental principle that is embodied in the statute, which is to internalize externalities relating to the environment to the extent feasible. That is a good policy from my standpoint. It's good economics. And the idea is across all environmental media, you try to ameliorate the impacts of development to the extent feasible. Now, this concept of feasibility is a fairly vague and elastic one. And one reason we have, I think, so many different judicial interpretations of it is that by its very nature, it's a vague term. It's similar to constitutional terminology like unreasonable search and seizure. And I think that one reason we have so much divergence amongst a lot of appellate courts is that CEQA is almost like common law in their hands. And even though it's a body of statutory law, and the legislature could change it tomorrow, the legislature could repeal it tomorrow, and the courts might say, geez, I love CEQA, you're taking that away from me. The legislature could do it, but the legislature up till now has given the courts these amorphous concepts. So it creates a lot of uncertainty. So I'm a believer in CEQA. I started out as kind of a young firebrand coming out of UC Berkeley in the late 70s, early 80s. The environment there was pretty far left, and I drank from that Kool-Aid. But it turns out that my life story is I've represented a lot of businesses and agencies over the years, and I have experienced some of the economic inefficiencies associated with CEQA. So what's troubled me over the years a lot has been that we have this statute with this wonderful policy about internalizing externalities, and it invites the public into the process. But the way the game, as I would call it, has evolved, people who don't like projects try to set up those projects for litigation. They put a lot of material on the record, which requires very lengthy responses, take a long time, a lot of money to respond to. And then they go to court. And sort of what seems like a fiction is that their concern is all about process and dotting the I's and crossing the T's. And yet it feels like they just don't like the project. And so we have 50 years of case law that's based on this game where the courts are interpreting amorphous concepts. And as Whit says, the older we get, the less confident we are about predicting what the courts are going to do. Now, you'd like to think if you had a doctor of my age, that doctor would have a good idea of what's going to happen if you go into surgery. Ironically, in our field, you might have a 35-year-old attorney who will tell a client, I know you're going to win, or I know you're going to lose. And Mr. Manley and I would say, well, there's a lot of variables out there. You know, here's some of our experiences. We thought we had a slam dunk. We lost. You just don't know. And so in anticipation of that, you engage in what we call gold plating or bulletproofing. Spend a lot of money trying to improve your odds in court. but it doesn't always work. And as Mr. Manley said, sometimes these cases take up to 6 years. I was in this Bryant Ranch case that the last speaker talked about. I'm still in it. That was a 2011 approval. We are now on remand from the California Supreme Court in 2023, and we still need to go back to the Board of Supervisors. And I wouldn't be surprised at all if we're back in court, and I don't have any more years. We're going to be in court on this, and it's a senior housing project. So as I've struggled with these issues over the years, I'm looking for the sweet spot between environmental protection without any diminution in environmental protection, allowing people their day in court, and trying to eliminate or reduce these economic inefficiencies, which get passed on to ultimate end users. And I come back again and again in my own mind to hurrying up the courts. I understand they've got patent cases, they've got family law issues, they've got domestic violence, and everybody believes their case is the most important case. And I know there's workload problems. My idea, though, is, and admittedly, it's quite conceptual. It's subject to refinement by thoughtful people if it ever got legs, would be to create a specialized court and to combine the trial court and the Court of Appeal into one court, because what we find is that the action here in CEQA is really at the appellate level. So in a sense, the trial court is kind of a dress rehearsal for the Court of Appeal. So why not kind of just jump to the 3-judge or justice decision makers and do that in a rapid way? I think over time, the decisions would become more predictable because there would be a group of jurists with an evolving body of work, and people would read that work and they get a sense of what the rules are. There's still these amorphous concepts. And even if it remained true that people like Mr. Manley and I couldn't predict with a high level of probability what the outcomes would be, at least you'd find out what the outcome is relatively quickly. And then you go fix it and you're back in court, and then you'd go through it relatively quickly. Now, why do I think that CEQA and related land use laws deserve this level of resource allocation at a time of budget deficits and competing considerations and competing needs for money? A couple of reasons. Over the course of my career, I've seen my colleagues proudly go after housing projects and boast that they stopped housing projects in the name of precluding suburban sprawl, saving farmland, saving habitat. Now some of these same folks say, oh, you can't blame me for not having as much housing. And what's changed over that 40-year period is that now we have kids who are 30 years old and more, and they can't afford a place to live. The millennial generation doesn't have $1 million for a mortgage in California. And so we have this very unequal society with older people like me with a lot of equity, and we just sit back and watch our equity grow, and our kids are either living at home or renting, or they're totally dependent on their parents to get a place to live. So I think there's this income inequality that makes housing production a very high priority for the state. And I would say, if I were in front of the legislature, spend some money on getting this done. The other thing, which is to me a more paramount issue, is I believe that if we're going to deal with climate change, we have to think of ourselves as being at an era of a time of construction that would rival what Franklin Roosevelt did during the 1930s and what Pat Brown did in the 1950s and 60s. Under the Inflation Reduction Act, the feds are trying to incentivize more wind power, more solar power, more electrical lines to take this clean power, electrical car charging stations. And so we need to build things for the environment. So we have a bar, part of the legal profession that is, from the petitioner's standpoint, used to dragging things out, taking more time, more process. You're in court for years and years, dot every I and cross every T. And it doesn't feel to me like, even though I hear them say we're in a planetary emergency, that they are willing to adapt to allow construction of all these new types of infrastructure to proceed. So If we had a land use court, we could build the housing more quickly, and we could go green more quickly. Right now, we have incredibly ambitious climate goals that are enshrined in statute, carbon neutrality by 2045. And I honestly hear about these things, and I hear about everything that needs to be built. And I say to myself, we will not be able to do it. We don't know how to build things anymore. And so this is what's motivating me in recommending what seems to me a sweet spot. You keep CEQA, it's stringent, people get their day in court, and yet we try to get rid of some of the waste in terms of time and money.
Commissioner Byers raised his hand.
Thank you. I want to return to the specialized court, the pros and cons, which are noted in the staff memo at footnote 12, for those who want to look it up. And I've been involved in creating specialized courts as a congressional staffer many years ago. And so I know the pros and cons, but maybe if the witness could address the concerns of the Judicial Council and other opponents, that is the risk that there is effectively regulatory capture of such a court by the interests of, let's say, developers or agencies, as opposed to a fair balance system. And that such courts operate with blinders, they create insider game theory problems. How do you respond to the criticisms of specialized courts?
I was unaware of the staff report, so I'm unfamiliar with the footnote. And it sounds like you have experience on this, and I don't. I'm the first to admit that my idea is very conceptual and may not be fully baked. I'm really hoping to get a conversation going. On the issue of regulatory capture, my letter suggests that there could be membership requirements that would try to avoid that. There are various regulatory agencies in California where by statute there are varied membership requirements. So here you might have requirements that an appointee have a background with environmental organizations. You might have a balanced need for people with agency expertise. This is a court. I would hope if it were to come to fruition, it would be as open and transparent as any other superior court or court of appeal. Frankly, they're not that transparent, particularly at the appellate level. It's like tablets roll down from Mount Olympus. You get 15 minutes to argue to them. But I hope that people of goodwill like yourself, sir, with experience on this kind of thing, could try to design a system that would work. My paramount concern is speed. I, like Mr. Manley, have had cases that languish for years and years and years, and there are no injunctions in these cases because they're not necessary. Banks, in my experience, will not lend money until the last CEQA case is gone. And so someone just could file a totally spurious lawsuit, and it may take 5 years, and no dirt is moved during that time period. And that could be for a solar plant, it could be for a wind plant, it could be for new transmission facilities, it could be the most environmentally benign project out there, but it's still subject to that time delay. And I just think there's so much work to be done to deal with climate change and to get some inequality remedied in California, that we just need to find a way to move the courts along more quickly. But I'm open-minded other ways. I just think this strikes me as a good way to go.
Yeah, well, without belaboring the point, there are many, many specialized courts in the federal system, in various other states. Internationally, it's pretty common. The difference between the specialized courts and the CEQA example is the problem that you're seeking to solve is the knock-on societal effects of delay or confusion about what the rules are, because it's hurting the achievement of some other societal goal like housing or climate change mitigation. Most of the other specialized courts deal with tax or international trade or tariffs. They don't necessarily disrupt a major economic goal of a state or a country. And that difference cuts both ways. Thank you.
Thank you. I understand Commissioner Hernandez has over on this end.
Sure.
Sure. No, go Bears. So good job for that. No, just following up. I mean, you don't have to read footnote 12, but from your experience, I mean, what are some of the, I guess, negative aspects of having a specialized court?
Well, since I haven't practiced in front of a specialized court, I don't know what those would be based on my own experience. I understand from Mr. Selmi's letter and from what the gentleman just described that there are concerns about capture, regulatory capture. So I think that would be something you would try to design the system to preclude. I guess the worst case scenario is that the development industry basically backs a gubernatorial candidate, and the backroom deal is you put a bunch of right-wing hacks on your CEQA court. My sense of the near-term politics in California is that we're pretty blue. We have governors who try to get environmental support to get elected, and that probably wouldn't happen in the near future. But I think still you could design a system to try to minimize the possibility of that. Maybe there's some additional transparent aspects of the nominating system. People have to testify in front of the Senate before they're confirmed, that kind of thing. But I have offered up only a very conceptual approach. It's one lawyer's idea, just being in the trenches for a very long time, as how you might resolve some of this Gordian knot or cut through the Gordian knot.
I think Commissioner Sidley's light is on.
So, and building on not footnote 12, but the same concept here of specialized courts, tax court, et cetera. I think what Jim, you're trying to get to here and where this may make more sense is that what CEQA has become is so complex. So where we've heard Whit say and also Shiraz about how the documents are now so large and the modeling, the work done is so complex that if you give it to somebody who is more familiar with what CEQA is, then the preparation time might be less, which can also speed it up. These documents are overwhelmingly complicated now for even a more simplified project. Again, I speak from being at the Port of Los Angeles, where we had probably some of the most complex documents in the state. But even smaller projects are very complex, and we've taken them into court, and it takes a long time for the judge, the research attorney to just plow through the material. And sometimes they're asking particularly about modeling and, what is this model? How does this model work? Where potentially if you go to, I'm giving more of a speech than a question, I didn't mean to. But I think if you were to go with a more specialized court, they may know what's going on. The lawyers, the research attorneys, and maybe if it's not just a specialized court, maybe it's specialized research attorneys that travel up and down the state. There's a variation on this theme. And I guess if it's not specialized courts that combine the trial court and the appellate court, is there a variation on what you're thinking about? Or would they be, 4 or 5 of these up and down the state? Would they be cross-jurisdictional? As you're thinking through, I know you said it's very high level, but as you're thinking about this, I can't imagine it's one in every county. So, what are you thinking?
Yeah, I hadn't envisioned it as one court where everyone had to go to LA or downtown San Francisco. Again, it is totally conceptual. Either circuit riders or, moving around the state. Sometime you're in San Diego, LA, Fresno, Sacramento, Redding. People would have the opportunity to participate by Zoom, but it really is a conversation starter. My main point is we need speed. I would say though that I've had the experience many times of waiting for my case to be called and seeing the tremendous variety of issues that a Superior Court judge needs to deal with, and thinking, boy, what a hard job it would be, because they go from domestic squabbles to a guy in an orange jumpsuit who's getting arraigned, to name changes. And then I come up and I spent my entire adult life immersed in CEQA. And I know way more than they do. But if I were on the bench dealing with these other items on their calendar, I would mess it up and probably create appealable issues with great regularity because I couldn't possibly keep all that stuff in my head. So what we have is generalist judges, specialized attorneys. We don't have generalist doctors. I had surgery getting within millimeters of my spinal cord 15 years ago. I was very happy to know that that surgeon had done 100 surgeries before he got anywhere near my spinal cord. If it was a general practitioner and said, hey, let me open you up and see what's in there, I would have, would not have been as confident that it was going to turn out okay. So I just think there's kind of an anomaly. Generalist judges, extremely complicated cases, and with the tremendous social and economic ramifications of this very, very slow dispute resolution system we have with respect to housing, all other projects, but also what we're going to need to build to deal with climate change in a realistic fashion.
All right, Commissioner Garcetti has a question, and then I respectfully suggest that we move to the next expert, but please go ahead.
Thank you. Speed, speed, speed. I mean, I think you got the attention of everyone. For those of us who are not familiar with CEQA, we started getting it early on. As soon as we started reading, how long is this taking? What's going on? And then you see the eventual results where everyone loses. Maybe there's a winner slightly, but it's costly. And so we all lose with that process. The idea of specialized courts with an S, throughout the state is attractive, but I'm also concerned that we could have a mini US Supreme Court where you have stacked judges and hey, you're not going to get a fair hearing here because of their thinking, where they are, be one side or the other. How do we protect that? And I'm not asking you to answer it, just my question right now, because this is conceptualized, but I am asking you to answer one question. Since you know so much about this and you're respected as an expert in this, you've probably talked to judges, you've talked maybe to legislators about this. What response are you getting? Because if we ever issue a recommendation that touches on this, we don't want it just as a recommendation. We want something to happen with it. And we need to know the political playing field here. And we have ways of finding that, but you're really in the trenches.
I wish I were better connected politically than I am. I have not spoken to legislators about this. I would love them if they'd say, hey, we hear you know about this. What you got any ideas? But that's only happened very, very rarely. I know one Court of Appeal justice pretty well. I find the others seem to stay on Mount Olympus and not mingle with us mortals too much. And that's good. They want to not be seeming to favor people or be too friendly with other lawyers. My sense is they'd be against this because it seems like dumping a lot of additional work on them on top of a busy
Even if
schedule
they
they've
were
already
given
got.
additional resources?
What's that?
Even if they were given additional?
No, I think that's the
resources?
key. There'd have to be a lot of additional resources, basically a bunch of new judges, and they'd be in this new court. And then that actually would free the judges in the current system not to have to deal with these cases, and they probably get their other work done more expeditiously.
Thank you.
Terrific, great. Thank you very much, and thank you.
Thank
for,
you. I
your
appreciate the
perspective.
opportunity.
Witness?
Thank you, Mr. Chairman. The next witness will also address the issue of specialized court, although from a very different perspective. He is Daniel P. Selmi. Mr. Selmi is the Fritz B. Burns Chair in Real Property Emeritus at Loyola Law School, where he has taught for 38 years. He has written extensively, or he did teach for 38 years. He's written extensively on the land use law and environmental law areas and co-edits the 7-volume California Environmental and Land Use Law Practice, True Beach Reading. He is a past chair of the State Bar Committee on Environmental Law. He is an elected member of the California Academy of Appellate Lawyers and has argued 40 appeals in the California and federal appeals courts. Certainly has extensive experience in CEQA. He holds a JD from Santa Clara University and a BA from Santa Clara and an MPA from Harvard University. Commissioners should note that Mr. Selmi Like Mr. Moose, Mr. Selmi wrote to the commission arguing against creation of a specialized secret court, and that letter begins at page 71 of the packet for this meeting. And with that, Mr. Selmi, you may begin. Shiraz, is he online? Okay, Mr. Selmi, Professor Selmi?
Can you hear me now?
Yes, now we can. We cannot see you, but we can hear you.
You can't see me. Oh, let me try to fix that too. I don't know why my video won't start.
Well, that's all right, Professor Selmi. We can hear you, and that is most important. So
That's not so hot. Let me just say thank you for the opportunity to appear. Commissioner Sidley, nice to see you as well. Been a long time. And
Pleasure.
nice to see Whit and Jim as well. So Professor Rick Frank and I at Davis wrote the
now we can see you, Professor Selmi. Thank you very much.
Thank you. Wrote opposing the idea of a secret court, and I'm going to talk about that and the reasons why. I just don't think it's a realistic solution. But I want to just push back on a couple of points to begin with, though, in defense of the courts. Frankly, there's been some allegations, not necessarily here, that the courts are biased and result-oriented in their decisions. And I think that's an extraordinarily serious charge. I want to push back on it as far as I can, because I certainly haven't seen it. I think they approach the secret cases in good faith and do the best job they can with it. And if I were you, I simply would put that aside as a consideration here. I want to talk a little bit about the inconsistency in decisions. The idea that we need more certainty here. I think I have a basic disagreement with both Whit and Jim about how inconsistent the decisions are. I suspect if I represented developers, they probably would find them more inconsistent. But the subject of GHGs and wildfire came up as promoting inconsistency. And I think that's the point. This law was put into effect 50 years ago as a prophylactic measure that was intended to be both flexible and action forcing. And the reason it got put into effect was nobody was considering environmental effects before approving projects. As the law evolves, you're going to get new areas of environmental concern. GHGs and wildfire are certainly those. And yes, it's going to take some time to sort those out if the legislature doesn't intervene and put something in effect. I think that's inescapable from the nature of the project here. Do I think there's that many areas of inconsistent decisions or decisions where you have conflict? No, I don't. I don't think there's that much. But I would keep in mind that this is supposed to be an action forcing statute, a statute that forces governmental agencies to look at impacts and then to mitigate them. And that's the process we're talking about here. I'm also concerned that there's a sort of theme here that the decisions of the appellate courts are not of the best quality. And I want to say that in general, I appreciate your reference to my treatise, but I have another book you may want to buy called State Environmental Law that I go through every year. It's got all 50 states in it. So I have to go and read the appellate decisions of the 50 states to do the update. And I come back from that every year appreciating the California courts more, because believe me, the quality of the decisions that we read in California is far superior to some of the things you can see in some of the other states.
Professor Selmi, just your friend Jana. I just want to be clear that I have not heard anybody on this commission doubt the quality of the justices that are making these decisions. I think we are talking about speed. I think we are talking about complexity of the work and the workload. But I want to just be very clear. Nobody is criticizing the judges. Thank you.
Okay, I appreciate that because I've seen references to bias and result oriented. Now let me get to the specific issue of what I see what the problems are with a secret court. The first is you have to understand you're creating a subject-specific court in a very narrow controversial area. You will get increased expertise, presumably through the appointments, but I would suggest that the specificity of that subject matter and its importance is going to make the appointment process extraordinarily politicized. I think you're going to have the equivalent of California Leonard Leos running around vetting candidates. I think you're going to have lobbying. And I think in the end, the process is going to turn into something that will politicize the court. Its legitimacy is going to be questioned from the get-go. We've seen examples of that certainly at the federal level. We saw an article, if you saw a couple, what's going on in Florida. I don't think we want that in California. Now, there's an argument, I think, that, well, if we can have enough wide expertise in the justices, that will solve the problem. Well, there's the question of what differing perspectives are. We've had the same issue arise with specific requirements for state boards. I don't think in the end that's going to solve it. So I'm afraid that in the end, what you're going to have here is a court that's viewed very differently from other courts. Then there's a whole series of implementation issues that have to be dealt with. One is, what's the role of prior case precedent to this court? Is it a regular court with judges in which they would follow stare decisis and have to follow the prior precedents? If so, presumably they would have to accept those and follow them. So if you're looking for sort of a wholesale change in the decisions, you wouldn't get it. Or does it have broader authority to reform CEQA precedents in some way? And as I read the proposals, I think there's some hint that this court should have broader powers than normally exercised by courts. If so, that power would have to be defined, and it would be novel for a court, no question about that. It would be unique, at least at the state level. We generally don't create special courts for other difficult areas of law. We don't have special probate courts. We assign existing judges to do probate, juvenile work, family law. So you're going to have a unique court here, and that, I think, that idea sets off, at least in the past, alarm bells with various entities, including the Judicial Council. And I think that's going to set the same alarm bells off this time. There are, environmental courts throughout the world. In the US, though, I think it's only Vermont that's tried this for a long period of time. It's not an idea that caught on.
Professor Selmi?
Yes.
Excuse me, this is Vice Chair Varner. I think Commissioner Byer has raised his hand and would like to ask a question.
Sure. Well, thank you. I have been on both sides of this specialized court issue, but let me push back a little bit on your claim that it wouldn't work. There is a U.S. Court of Federal Claims dealing with claims against the government that are large and complex. There's the U.S. Court of Appeals for the Federal Circuit, which deals with both patent cases and cases against the government. There's the Court of International Trade, the Tax Court. There are specialized state courts, including family courts, environmental courts, probate courts, tax courts, workers' comp courts, water courts, land courts, administrative courts, small claims courts, and juvenile courts. So the idea, per se, of a specialized court is something that's broadly accepted in U.S. jurisprudence. The arguments that you're making against this court seem to be based on a desire to maintain the status quo. If you're against specialized courts, how are you going to improve the timing and certainty of outcome in the current system of CEQA appellate jurisdiction?
Certainly, and I don't want to seem like I'm advocating for the status quo. I'm simply pointing out that I think that there are a series of problems, and there's other ones I haven't mentioned here as well, that would have to be overcome for this kind of court to work. And
okay, so let's just assume that we decide that there shouldn't be a specialized court. Will you agree or stipulate to the fact that there is a problem, that cases take too long and the results are inconsistent, which is hurting the desired public policy outcome of more housing or more climate change projects?
I will not stipulate to that entire statement, no. I will stipulate to this, though, that I believe, and I think that I'm in agreement with Mr. Moose and Mr. Manley, that the delay here is in CEQA litigation is too long and is unacceptable. And I
Okay,
think
thank you.
that has to be addressed. I do not agree that that CEQA is a primary cause of the housing shortage. I think you have plenty of evidence on that yourself. You can deal with it. And I, as I said, I think I don't agree that there's necessarily more inconsistency somehow in the CEQA cases. One thing, and I'll get to your point about what I would do here, but I think it was Commissioner Barr that said that there's a breach in which the judges are invited to adopt their own views. I don't think judges adopt their own views. They simply try to apply the law as best they can here. So, I mean, that's where I'm coming from. Now, I want to come back to the delay. It's real. It's not in every case by any stretch of the imagination. And I don't think CEQA cases are a huge percentage of the CEQA decisions, but it can be a serious problem when a case is delayed for a long time. And I think there's room for considerable improvement, as our letter stated, that we think can be improved. Now, so you probably be looking for the magic wand on what could improve the delay. And the problem is it's a more complex question to fix than it would seem. And why is that? Lawyers don't like time constraints put on them. Judges don't like time constraints put on them. Municipalities don't like time constraints put on them and things like preparing records. Any solution to the time problem is necessarily going to burden everybody involved. But I do think that there is an overriding public interest in getting CEQA cases decided much more rapidly than they are now. I think there's room for considerable improvement here in that respect. In particularly, it seems to me we prepare administrative records, like the digital age doesn't exist. But again, that's going to put a burden on parties to do that. I was telling you, I when I first started practicing law, I got a law school, I clerked for a federal judge. And parties used to come in and there'd be a pretrial conference and they would say, well, Your Honor, I would like the trial in about a year and a half. We have about a year's worth of discovery and then we're going to, we have various motions. The judge would say, fine, you're set for trial in 6 months. And they'd hate it, but they would deal with it and the cases would get decided. This process has to be speeded up, but it's going to take a coordinated effort to do that. And it's going to require an effort that makes the various entities do things that they would prefer not to do. One thing I want to mention about the delay is it's certainly not entirely the court's fault. I agree with Mr. Manley. You get different at the Court of Appeal level, you get different times. This is true for cases generally in the Court of Appeal. Some courts of appeal are more caught up than other ones were. So you get different from the time from briefing to oral argument can differ. But in general, I think that the other factors that go into delay are things like the preparation of the administrative record, which can take forever. The briefing schedule, lawyers like to make it comfortable for themselves, continuances, and then there's, of course, the trial court's calendar, which is can be a problem if you have a CEQA judge. That can vary. All of these things go into the delay factor and have to be dealt with.
Let me ask, Commissioner Beyer, did that respond to your question? Because I have Commissioner Hernandez who has something.
Yes.
All right, thank you very much. So Commissioner Hernandez.
Thank you. Now, similar question to the last witness. I mean, it sounds like you have a whole array of reasons why we should be concerned about a special court. But in that, you touched upon a couple of positive things. I mean, so are there any positive things from your experience in terms of having that increased expertise or maybe something around the timeliness? Or do you see it as just as a negative endeavor?
No, I think having a court with a specific expertise can certainly have benefits. They don't have to invent the wheel every time. Maybe they would write opinions faster. I sort of doubt that. But I suppose that could happen. I think the specialization could have benefits, yes. And I think that's sort of, an obvious idea why the thing has superficial appeal. My objections to it are that one is the politicization objection, because I don't see anywhere around that. But I also, there's a number of other sort of.
So just on that, so you're saying that right now the process is not politicized?
I don't think that the judicial process is, no. I think the judicial process is one in which you go to court and you make your argument to judges. But then you'd go to court, you'd know who's going to hear these cases. And I'm very concerned about how that court's going to get appointed. But there's other problems associated with it as well. One problem that would have to be worked out, for example, is, okay, it's a CEQA court. CEQA cases are often combined with other causes of action. Is this court going to hear all those? The other causes of action can be land use causes of actions. Or when I used to defend the Air District in CEQA cases, they were health and safety issues. Okay, so this court decides all those. But if those issues arise elsewhere, the regular court decides it. You're going to have to decide the jurisdiction of this court. I've heard reference to a land and natural resources court. I think that's a difficult question to decide what it's going to hear. There's the expense and need for resources. You obviously can see that. And there's also the problem that smaller jurisdictions are not going to be happy with the solution. They're not going to like the idea that the case is taken from their county and is sent to Los Angeles or San Francisco or something like that. I think cumulatively, all of these issues raised to a level where it's just not a good idea to spend a lot of time on it. I mean, if you want, I suppose you can recommend it, but I think you would use your time and resources much more profitably, focusing on some of the more specific issues that have been presented to you. That's just what my point is on it.
Yeah, thank you. You responded to his question. You may go ahead and continue.
I don't think I really have anything more to add to my presentation regarding the idea of a CEQA court. I think I presented most of it to you as far as why I think that there's problems associated there. So unless you have something, and I'd be happy to entertain any further questions. It's kind of fun. It's a little like oral argument in a court when you get interrupted, and that's always the best part of it.
Yeah, except you have us at a disadvantage. I think you know more about it than we do. So looking at fellow commissioners, seeing no further questions, I just want to express our gratitude to you for taking the time for your written material along with your presentation here today. Thank you, sir.
Thank you.
So to the commissioners, we've got 11:15. We could take a bio break. Should people want to do that for about 10 minutes? The lunch is here. I would suggest, given the time that we have, we can use it to hear public testimony. So we could take public testimony now until 12. If no one wants to. Yeah, okay, fine. So seeing no severe and dire objection from any commissioners, let me turn this back over to Ethan Rarick, and we can then open up the podium as well as the Zoom and phone calls for public testimony.
Thank you, Mr. Chairman. So we'll now move to the public comment portion of the agenda. We'll start with public comment of those members of the public who are in the room, and we'll then take people online. For members, whether you're in the room or online, let me note that public comment, in keeping with the commission's practice, is limited to 3 minutes per speaker. So we'll limit to 3 minutes. And I believe we are trying to make sure that you can use the podium for public comment. And we're trying to make sure that the microphone works. Shara, do you want to?
Testing.
Okay. I believe that it does. So you can use the podium to make public comment. If you've not filled out a form, you can bring them up to the staff. For
Mr. Reiser.
benefit of the commission, let me mention that the fifth witness, Judge Reiser, has a time set in his own schedule. He cannot testify until 1 o'clock.
Okay.
And he then has a hard stop at 1:30. So we cannot take Judge Reiser right now because of his schedule. Okay, so we will begin with public comment. The first request to make public comment is from Christina Caro. Ms. Caro.
Good morning, Chair Nava, members of the commission. My name is Christina Caro. I am here on behalf of the State Building Construction Trades Council of California. State Building Trades represents 500,000 men and women in the construction industry, including about 70,000 members who work in union apprenticeship programs. Of those apprentices, 3/4 of them are people of color. About 1 in 5 come from foster care, from youth homes, or from the criminal justice system. So a very broad range of clients.
Let me offer an apology. There's a commissioner has requested the
I'm
opportunity
sorry.
to say something.
I just want to let you know that the subcommittee meeting, Ms. Sidley and I had a conversation with your CEO this morning and wanted to appreciate the fact that he reached out to us to ask to have a conversation, which we had this morning, and it was very helpful.
Thank you very much, Commissioner Aaron. I'm glad you were able to speak with him directly, particularly given the limited time we have for public comment. The building trades did submit a letter, as you're aware, on June 13th, which provided the commission with facts and with a history of union participation in the CEQA process, including some of the environmental achievements that members have accomplished through years and years of work on improving environmental and public health impacts. The letter also explained the importance of CEQA in protecting the health of union members and their families, many of whom come from disadvantaged communities, and in giving workers a voice in the process of the developing projects in their communities. The letter also clarified some misstatements that were made by witnesses in past hearings about both unions and about the public's participation and the process that the public holds in CEQA. Union members, including our members, live and work in the communities where their projects are built, and because they build many of these projects, they're subject to first-line exposure to health and safety impacts and to construction impacts and operational impacts. CEQA gives these workers a voice in mitigating impacts and also in protecting their communities. The participation in the CEQA process over the last 50 years, as I'm sure you know, has resulted in thousands and thousands of tons of reductions in air pollution from refineries, power plants, and other industrial facilities as a result of union members' participation. We've also commented and participated in thousands of commercial and residential projects, which have resulted in the cleanup of contaminated soil to residential levels, reduced construction pollution, reduced cancer risk to local residents who are surrounded by construction, and improved water quality and energy efficiency. These results would not have been achieved but for the public participation process and the environmental mandates of CEQA. So the commission really must recognize the benefits of CEQA in preparing this report. Also that, you know, the issues raised by developers about time, about process, that is all what CEQA is intended to facilitate. It may need to be sped up, but developers may not like the process of public participation in mitigating impacts, but that process is critical for California's sustainability. I would note that a 2023 study by the Rose Foundation, which we cited in our letter, actually finds that only 1.9% of all projects that are subject to CEQA review are subject to a CEQA legal challenge. So what we're talking about is a bit of a vacuum that applies to a very small percent of projects in the state. And of that 1.9%, only a quarter of those are housing projects. CEQA has also been streamlined to promote housing production and to promote low impact development, and those streamlining measures have worked. So we urge the commission not to recommend any further changes that would undermine public participation, that would discriminate against specific groups of people, or that would weaken CEQA's public participation and environmental mandates. Thank you very much.
Thank you, Ms. Caro. Next, we will have Francis Tinney, I believe is the last name. Francis Tinney? Yeah. Go ahead, you have 3 minutes.
Great. Thank you so much for the opportunity to comment today. My name
Can
is.
you pull the micro? Yeah, there we go. Thank
This
you.
good?
Yes, there we go.
Yes, great. Yes, my name is Frances Tinney. I'm an attorney with the Center for Biological Diversity and a Bay Area resident. And what I wanted to talk about today is that ever since CEQA went into effect in 1970, there have been calls to tweak it, to reform it, to throw it out completely. But as the climate crisis intensifies, we need more access to environmental information. We need more public participation, and we need to protect CEQA now more than ever. It's only through CEQA's environmental review that communities find out which projects are safe and which projects aren't. CEQA can't fix the state's housing problems, but it certainly didn't cause or exacerbate the crisis. As a living law, CEQA has already been modified to streamline the process for affordable housing, infill housing, supportive housing, homeless shelters, and many other uses. We can't ignore the importance of mitigating environmental impacts because we need to build homes. To address the affordable housing crisis, we should focus on real impediments to building homes: high construction costs, restrictive zoning, inflation, and local agencies that ignore their housing mandates. Weakening CEQA does not automatically create more housing units, but weakening CEQA does lead to more dangerous projects that harm the environment and public health. CEQA is the best tool we have in California to achieve environmental justice. CEQA requires agencies to disclose the environmental impacts of a neighborhood project and allows the public to comment. In disadvantaged and low-income communities, which bear the brunt of air pollution and environmental racism, CEQA presents the only opportunity for those neighbors to learn about a polluting warehouse or oil drilling project coming to their backyards. The law allows communities to hold their elected officials accountable to mitigate these harms. Thank you for the opportunity to comment.
Thank you, Ms. Tinney. We will now move on to Jeremy Smith. Mr. Smith.
Thank you, Mr. Chair, members of the commission, for your time today. Jeremy Smith here on behalf, a second speaker on behalf of the State Building and Construction Trades Council, wanted to give the perspective of all of our building trades councils up and down the state. Sure, I'm very sorry. We appreciate the committee's time today and the previous meetings to discuss CEQA, one of the state's most important environmental, public health, and protection laws. It's important to note that CEQA has already been amended over 20 times just over the last decade, just for residential housing construction, and already includes over 40 streamlining exceptions. Yet we are still here today because construction is not happening. We submit that this dearth of construction is not just because of CEQA, it's because of the entities that have to deal with it. And what has not been discussed today or in your previous hearings on CEQA is the developer's role in the construction slowdown. With respect to a previous speaker, we do know how to build things. It's the developers who are making profit-driven decisions about when and where to build. For example, in the city of San Francisco today, there are over 48,000 entitled housing units that remain unbuilt. A similar situation is occurring in Los Angeles and in cities up and down the state. Furthermore, there is a national housing shortage. This is not a California-specific problem. States, as you can imagine, with much more lax environmental protection laws are also struggling to build housing. There is a profit motive here by some of the housing developers that we would ask be discussed in your final report. Furthermore, the land use permitting process has been shown by numerous studies to be an impediment to housing construction as well. High land acquisition costs, local zoning limitations, local constraints on density, lack of financing, or in current day, high financing costs, and local land use entitlement processes also play a role here. CEQA is a critical law to help ensure that our members are not exposed to unsafe and unsanitary working conditions when they are beginning and carrying out their construction work. It's important for their families and communities who experience the long-term impacts of development where they live. Unions and their members have presented decision makers with evidence about those impacts, and we only ask them to mitigate the impacts through CEQA review. Thank you again for your time today and the previous hearings. We appreciate your
Yeah, Mr. Smith, before you leave.
Oh,
could
sure.
you give us some information about the young man that's sitting back there with you?
Oh,
Can he come up to the mic?
oh. This is my son,
Yeah.
Tyler. He is a Star Scout in Troop 8 here in Sacramento, and he is here attending a public meeting as part of his communications merit badge requirements. So he's been taking notes. If the person taking the minutes of the meeting need any kind of discussion about maybe they missed a name or something, he probably has it.
Well, I just want to thank you for attending our meeting and paying as much attention as you did, and it's a pleasure to have you here.
Just a quick question.
Your badge. I'll say you were here for the here.
Perfect. We need witnesses. Yes, thank you.
Exactly.
Thank you.
I think the other commissioner actually has a question.
Am I allowed to ask a question? Oh, no. Thank you for the testimony. Just clarification. I know in the past, the building trades have supported some CEQA exemptions for some energy projects or also some building of different sports arenas. And so just a quick understanding in terms of the having parity, in terms of you're arguing more in terms of on the housing side, there needs to be something, but what about on the energy, transportation, and other projects? Well, a lot of those projects that we have supported in the legislature, the streamlining provisions have included perhaps labor standards, or we've been able to engage on the local level. And if we had labor standards for all projects, I mean, within the CEQA, I mean, what if that was a solution in terms of expediting some aspects? No, we don't walk away from environmental concerns if we get labor standards on projects. We still engage in the CEQA process because we want to make sure that places where things are built, this is an extreme example, it's not being built on a former gas station lot, right? Or our members aren't going to be exposed when they start turning over dirt. So we don't back away from the environmental process if there are considerations for the workers that are building projects.
All right, next public speaker. Thank you very much.
Thank you very much. Next, we have, I believe it's Jonathan Pruitt, and I apologize if I'm misreading the last name on this form. Okay.
Thank you for having me. Good morning. My name is Jonathan Pruitt. I am with the California Environmental Justice Alliance. CEJA is a statewide community-led alliance that works to achieve environmental, climate, and social justice by advocating for state policy solutions. And CEJA supports a just transition to a clean and renewable energy system that prioritizes the retirement of polluting infrastructure in the environmental justice communities. And it's this transition that involves developing and replacing with clean energy transition, clean energy generation, storage, and distribution. And it's through this transition, it's really crucial that we honor the community leadership, protect against the false energy solutions, and ensure that tangible benefits and those investments go to the environmental justice communities. I want to provide a response to sort of like policies like the governor's CEQA trailer bills, which I hope will provide more of an environmental justice perspective as to this thing. CEQA is essential for EJ communities to ensure their voice is heard during land use planning, protecting their environment, their environmental health, and promoting clean air, water, and soil. And while we understand that the administration's desire to create greater certainty and faster timelines for CEQA-related lawsuits, such policies can actually disproportionately harm low-income neighborhoods and communities that are predominantly Black, Indigenous, people of color, causing environmental damage if implemented poorly and diverting attention from effective solutions to our environmental challenges. And it's this type of dynamic that's complicated by the fact that low-income and BIPOC communities have few resources and limited access to legal advocacy compared to rail resource industry and special interest groups. And to top it off, we have public agencies that often seek to push these projects that harm EJ communities. So the governor's CEQA trailer bill for the judicial review provides a broadly defined list of proposed clean projects. And those may include harmful energy systems and approaches that increase pollution and extraction in EJ communities, such as dirty hydrogen, biofuels, and carbon capture and storage. And the issue with the policy proposal from the governor's office is that it doesn't include protections. Those protections that expedited projects will not exacerbate that local pollution that will be faced with the disadvantaged communities. And the state should not be providing judicial streamlining projects, the streamlining for projects that threaten severe environmental health related harms for EJ communities, both during construction and operations. We should engage in more careful consideration deliberations about whether or not these projects should be built and where they should be built. The CEQA trailer bill also includes a change in the administrative review process. We heard about that throughout today. And in the narrowly defined scope of internal agency communications, unfortunately, it does not include, it says it's going to take out parts like emails that were not presented to the final decision-making body. And for community-based environmental justice organizations, we traditionally relied on those communications because they provide a mirror to the environmental review that was done.
Mr. Pruitt, your 3 minutes has expired. Can you wrap up quickly?
Yes, I will. Thank you so much. So we urge decision makers to prioritize the protection and the enforcement of CEQA as a critical tool for promoting environmental justice and safeguarding the health and the well-being of all Californians. And it's crucial that CEQA's protections are not watered down or weakened. I thank you for your time.
Hang on just a second. I think Commissioner Sidley has a question.
Hey, Mr. Pruitt, I'm just curious, do you have a view on having a specialized CEQA court or no CEQA court?
For me, I would have to, because we're an alliance, we would have to really speak with all of our alliance and see what it is, because all of them do have their own lawyers and that sort of thing. So we would have to all talk together on that.
Okay, just curious. Thanks.
Thank you, Mr. Pruitt. We now have Gracia Orozco. Apologize if I'm mispronouncing your name. And after that, just so that people can be ready, next will be Diana Cruz. If you can pull the microphone down towards you, that would be helpful too. Thank you. Oh.
I'm a little, okay. Can you hear me?
Speak up if you
You're
can,
gonna have to
please.
speak up.
Okay. Well, good morning, chairs and members. My name is Gracia Orozco. I am a staff attorney representing the Center on Race, Poverty, and the Environment. We are committed to representing environmental justice communities in the San Joaquin Valley. Our neighborhoods are and have been historically divested from. There are higher rates of poverty. We represent low-income communities of color. And what comes with that is a higher rate of health issues associated with polluting land uses that have plagued the San Joaquin Valley. As such, we have residents complaining of elevated levels of asthma and cancer. Children as low as the age of 9 are getting prostate cancer in our regions. And these are all due to the amount of hazardous waste facilities, the oil and gas industry, and all these hazardous projects that have made their way in. CEQA is therefore pivotal in making sure that our community members stay informed about these harmful projects that are continuing to try and target the valley. It's also a mitigation tool to prevent more harm that is already caused in these overburdened communities. First, I'd like to talk a little bit about notice. There are already a limited number of ways for environmental justice communities to stay informed and voice their concerns about projects, and that is through CEQA. There's notice requirements for projects, and these communities that are already at capacity for harmful development would only be able to otherwise say what they'd like to see, what's a harmful project or not, through these requirements. And I'd argue that the notice requirements aren't strong enough. So far, a lot of our communities are Black, Indigenous, or Spanish-speaking communities or other languages that notices aren't even translated. And it's often really easy for projects to slip under the cracks, and that's how they get approved in these communities. CEQA is also a mitigation tool. This is the first line of defense that we have to combat harmful and polluting land uses. In 2016, for example, our organization represented community groups in Arvin and Shafter against an ordinance that would streamline oil and gas drilling that would be placed next to homes, next to schools, causing further damage to the communities that are already overburdened by this industry. And without the Clean Air Act, not the Clean Air Act, we used CEQA to say that they needed to mitigate the air and water quality impacts that would be faced in these communities. With the talks about speeding up the litigation process, it would vastly disturb the amount of time that we have to put these cases together for our communities, there's less resources here to work with lawyers, the less time and people that are working on this. It doesn't matter for developers because they have all these firms doing doc review. But on the other hand, I'm just one attorney. Some organizations or some communities don't even have any attorneys that work on CEQA. And so shortening any time or placing a burden there would just make it to disincentivize these types of cases for these communities to help protect themselves. I'd like to conclude that our organization was to protect and strengthen CEQA to ensure that our communities have voices in projects that directly harm and impact them. I urge you to really look at the side of strengthening CEQA for environmental justice. Thank you.
Thank you. Next.
Just two quick things, just in terms of the narrative. And clarifying also for the commissioner. I'm pretty sure we're talking about improving CEQA. We never talk about replacing it or getting rid of it. So that's one thing. I know that a lot of comments. But two, a question for you. You just mentioned that if we are looking to increase efficiency, effectiveness in terms of the time aspect, that might have an unintended consequence in terms of a low-income community's ability to weigh in. And do you have, I think we talked about the 270 days and things like that. Have you had experience where, such a timeline, you weren't able to meet such timelines?
Thankfully, I haven't had that experience just yet, but I can say that oftentimes time is used to, gather funding and resources to even pay an attorney, and that requires doing fundraising. And a lot of communities use that time, and it's often really hard to get that in a community that doesn't have the means to do so. I know that one of the trailer bills is trying to also reduce the time to create an administrative record. These are really large records. Not everything is online or documented, and reducing time to do that would overburden these communities that only have one attorney, whereas firms have many different ones. So we could stipulate that it would be very harmful for these communities with less resources. They're already divested and to comply with these strict timelines.
Thank you.
Thank you, Ms. Orozco. Next, we have Diana Cruz, and she will be followed by Alex Lopez. Ms. Cruz. She is not in. You mean she wishes to make public comment remotely, or? Okay, we will try to come back when she returns. So, Mr. Lopez.
Good morning, Mr. Chair and members. Thank you for today's presentation. It was really helpful to hear from professors and practitioners. My name is Alex Lopez. I'm a current incoming 3L at UC Law SF, formerly UC Hastings, and a summer legal intern for CBE and here in support with CEJA. I just want to give a little bit of my personal experience being from Richmond, California, living next to a refinery. It's really important to have statutes like CEQA with the intent of protecting the environment, but additionally creating this public input aspect to environmental law and allowing transparency and accountability from agencies and the public to be involved in these processes. Living in a community that's overburdened, not just by environmental hazards, but also income inequality and other sorts of resource inaccessibilities that communities like Richmond face, having more streamlining bills or ways to amend CEQA to lessen that input and accountability aspect creates more stringent effects on communities like Richmond across California, because these communities have to understand what their agencies are putting in their communities. And sure, we have a housing crisis, as a lot of people in my community face, and especially in the Bay Area, but it doesn't mean that we need to take away some of these stringent protections that are created under CEQA, because it opens up the gate for other projects that can potentially harm our communities, like oil drilling, like dirty hydrogen projects that can be incorporated in these existing facilities, and other water projects that can affect our communities. So I just urge you to please pay close attention to what communities like Richmond have to face on a daily basis for decades. And if we weaken more of CEQA, what opportunities and other laws are there available for communities to have a voice? Thank you.
Thank you, Mr. Lopez. Ms. Canada, if you can tell me if Ms. Cruz returns to the room, we'll try to take her. But in the meantime, I apologize for mispronouncing your name, Mayeli Soto?
Good morning. Almost there, Mayeli Soto. It's a pleasure being here. Although I'm not a double bear, I did go to Berkeley for undergrad, so go Bears. Go Bears. I'm currently a UC Law SF, formerly Hastings Law student, and I have the honor of interning for Communities for a Better Environment this summer. There have been two ongoing themes in this meeting: speed, and the cost for developers. And I just want to give a perspective on the environmental justice aspect. I'm a first gen Latina. I grew up in Inglewood in Los Angeles County. And although I haven't firsthand experienced as much sacrifice as communities of color, my communities have experienced in other cities, I really want to be an environmental justice attorney and fight for these communities. And I just want to say that we are not trying to fight against development. We want green infrastructure, but we want communities of color and communities that are not in the conversation to be listened to be heard, and to be incorporated. Because what is the point of developing affordable housing units in a land that can be toxic? This is going to affect the health of these community members in the future. So it's almost going backwards. And that's the point about CEQA, that we are able to use CEQA to protect and to really assess what the effects are going to be, to make sure that this affordable housing has more positive impact, and not all the negative impacts that come with things that can't be caught if CEQA is not implemented, or if it's streamlined. And I wanted to point your attention to the administrative record trailer bill that's coming up, and just it's reducing the time from 90 to 60 days. And that's incredibly impactful in a negative way to communities of color. These communities depend on organizations like CBE or other grassroots organizations to defend them, and they already lack resources. So when thinking about these bills, it all comes down to these communities of color, which are sacrifice zones. That's what we're known for. We're known as sacrifice zones. So I just hope that you keep that in mind as you review these bills. Thank you.
Thank you. We will next have, and I apologize in advance for probably mispronouncing this name. I believe it's Kat Zhu. Okay, sorry.
Hello, can you hear me okay?
Yes.
Hi. Good morning, and thank you so much for the opportunity to comment today. My name is Kat Shu, and I'm a legal intern with Communities for a Better Environment. I just finished my first year of law school at Yale Law School in New Haven, Connecticut. I'm actually not from around here at all. I've spent my whole life in the Midwest and on the East Coast. This summer is my first time getting to live in this beautiful state, and it's been really lovely so far. I went to law school to be an environmental law practitioner because I believe deeply, as I think do you, that all people deserve to have clean air to breathe, clean water to drink, and safe and healthy environments to live, work, play, and go to school in. CEQA, I've always really thought of California as a national leader in environmental law and policy, and that's particularly because of laws like CEQA. CEQA is a really special and powerful tool for environmental justice that you have in this state. Low-income communities of color who have for generations been disproportionately impacted by dirty air, toxic water, and environments that make them sick have so few legal tools to assert their right to a healthy environment. CEQA is one of the key tools California has to ensure that these communities are not further made into unwilling sacrifices in the name of efficiency for everyone else. For example, it's really useful that CEQA's environmental impact report is more thorough and applies to a greater variety of projects than the National Environmental Policy Act or related statutes in other states. This is so important to ensure that we don't subject already overburdened communities to additional harm over gaps in analysis. In addition, the CEQA public engagement process and the ability for communities to litigate over CEQA are so crucial. In my year at law school, it's repeatedly struck me how infrequently the law and the legal system ensure justice and genuine procedural inclusion for people who are most vulnerable. The odds are forever stacked against overburdened communities and the under-resourced lawyers like us that represent them. As you consider changes to CEQA, I urge you to thoroughly consider how each and any of these changes will affect those who are most vulnerable and have the least access to economic and legal resources. And I challenge you to use your report as an opportunity to strengthen California's reputation as a national leader in bringing law and policy more in alignment with environmental justice. Thank you so much.
Thank you. Next, we have Jennifer Ganata. Commissioners may recall that Ms. Ganata actually testified at the first CEQA hearing clear back in March.
Morning again. Sorry for I wanted to actually make a brief public comment. My name is Jennifer Ganata. I work at Communities for a Better Environment. I'm a senior staff attorney there. And as you can see, we have many of our interns who came up. We were actually here yesterday with Seha talking to also legislators about the trailer bill package, basically. And so in hearing today's panel this morning, what kind of struck me is I think it is good to give resources to judges so they know more about CEQA. I do think right now, currently, a lot of our judges that hear CEQA cases have a lot of expertise. I can say that specifically about LA Superior Court and the writ judges who hear CEQA writ cases. But I do feel that the proposals for a specific specialized court system sounds like it's a different parallel track, and I'm kind of concerned about that. I feel like if you were thinking about creating a court system in that way, what does the access look like to the community? As many of our interns have already noted, it's already hard to litigate these cases if you work at a grassroots organization. So what does that access look like? Will you be speeding up the process? From similar to Mayeli's comments, what I did hear was about speed. So are we talking about speed and getting something developed, or are we talking about creating good projects? And I think that is what the process in the public comment period, in the EIR process of CEQA does. And as we all know, that not all those cases actually go into litigation. So I think to keep that into mind when we're thinking about changing the judiciary, what are those, like how would that impact like communities that CBE helps and serves? So thank you again for having this and talking about this. I appreciated Professor Selmi's comments. I think they were very important. I do know that there was a letter in the attachment for today's package, so thank you again.
Thank you very much. We'll now move on. I'm assuming Ms. Cruz is still not back in the room. So we'll move on to Cindy Heitzman.
Good morning, and thank you for the opportunity to comment. My name is Cindy Heitzman. I'm the Executive Director of the California Preservation Foundation. Representing over 20,000 members and supporters, our mission is to protect historic resources in California through education and advocacy. CEQA is the primary tool used to protect historic resources in California. Unfortunately, the majority of cities in California do not have historic preservation ordinances or even historic preservation elements in their general plan. And the vast majority of historical resources in California are not listed in the local, state, or national register. It is a dynamic list. It changes with time. And many of these resources are located in traditionally underrepresented communities in California. This is why CEQA is so important. When communities have discretion over approving projects that could impact historic resources. The fact that a resource is not listed or determined to be eligible for listing in the California Register of Historic Resources, or not included in the local register of historic resources, or identified on a historical resource survey does not preclude a lead agency from determining that the resource may be a historic resource as defined in the Public Resources Code. Absent inclusion in historic resources surveys, historic resources are often discovered through the CEQA environmental review. And this is why it is so important to have the environmental review process public and have it participated, and is often the only step to protect historic resources. We recognize that certainty and predictability and timeliness are sought in project planning. However, with respect to review of cultural resources, the basic steps that local government can take to facilitate this is lacking in many jurisdictions. As an organization, we have educational programs, conferences, we provide information to encourage this, but we're often at the mercy of local jurisdictions to incorporate these in their local government, which underscores the importance of CEQA in identifying significant impacts to historic resources through a public process to avoid or minimize impacts. Thank you for your time.
Thank you, Ms. Heitzman. We will now move on to Gabriel Greif or Greff? Okay, Greif.
So good morning. Thank you in advance for your time. I'm an attorney with the Emmett Institute on Climate Change and the Environment at UCLA School of Law. Although today I'm solely here in my personal capacity and I'm not speaking on behalf of my employer. I would like to briefly comment on the Bryant Ranch case that was raised today by a few of the panelists, purportedly as an example of CEQA's unpredictability and the litigation risk that it might create. As a refresher, the Bryant Ranch case considered a 2,500 unit senior home project. It's also in Fresno County, one of the most already overburdened communities in the state, near warehouse complexes, freeways, and agricultural operations. The project EIR expected that the project would generate 110 tons of reactive chemicals and 102 tons of NOx emissions. The court ruled that the EIR needed to consider what this means for the health of local residents and the thousands of seniors that might one day live there. Professor Selmi pointed out that CEQA is designed to be a flexible, action-forcing statute. Plenty of cases are very explicit that CEQA is designed to be a statute allowing the general public to meaningfully understand and participate in the environmental review process. To me and to the Supreme Court of California, this means more than providing a perfunctory estimate of how much of certain pollutants will be released. It means thinking through the actual impact a project will have on human health and the environment. So I would push back on the notion that the Bryant Ranch case was a major departure from CEQA's precedent or from CEQA's spirit. In the same vein, I find it interesting that this case is held out by representatives of developers and agencies as an example of CEQA's inefficiencies and as something that might need to be fixed. I see the Bryant Ranch case as a decision supporting CEQA's substantive mandate to protect public health and environmental quality, which should be supported and not eroded. Fundamentally, I see this dialogue around housing in CEQA as presenting environmental justice communities with a false choice between healthy and affordable housing. The most vulnerable communities, like all communities, deserve to have both. I would suggest keeping this in mind when considering proposals that may chip away at the fundamental protections and public participation requirements set out by CEQA. Former panelists have made the point that proposals like this tend to be a stalking horse to erode the foundation of CEQA and make way for more development. I would endorse that view and seriously consider that fact when considering proposals to chip away at CEQA's foundation. Thank you for your time.
Thank you. Mr. Chairman, we have now met and in fact exceeded our half hour of public comment. I'm aware that there are additional people online who've indicated a desire to make public comment. I would recommend that they submit written public comment to the commission by emailing us at littlehoover@lhc.ca.gov. That address is actually on the Zoom screen now, littlehoover@lhc.ca.gov. And I apologize, we were not able to get to everyone. So Mr. Chairman.
Let me just ask a question. How many people do you have lined up, backed up, that aren't going to present?
How many do we have online? Right. We have 12.
I don't know how the rest of the commission feels. I think 12 is kind of a significant number. I'm going to, and let me see how the rest of the commissioners feel about this. It's 12 o'clock. We've got lunch behind us. My thought is that we take 15 minutes and grab the sandwich and come back to the dais and then reconvene at 12:15. We can decide if we want to hear more public comment or if we want to proceed with the discussion of the sequel report or the other items on the agenda. So how about if we just break now, reconvene at 12:15, and we can talk about whether or not we'll do additional public comment. Yep.
I have one comment. If we are going to break right now, I would like to ask a general question of some of the participants because they
Yeah,
might not be
go ahead.
here after the break.
Go ahead, please.
Okay. How many of you are law students? Okay, good. I want to congratulate you, number one, for taking the time and effort to be here. Secondly, for taking the time to follow your interest and your passion in doing it. A couple of hints when you're addressing a group, an organization, or a speech anyplace, know your audience, first of all. This is a panel that is bipartisan. You probably know that, but if you don't, that's important to know. It's not a panel where you're seeking to become, I don't know, an appointment and then you're in front of a Senate committee where you know half of the people at least are going to vote against you regardless of what you say. These are friendly people for the most part. We are all friendly, I believe. And we are receptive to you and your ideas. We know you have a very limited amount of time, but don't race through it because you want some of your ideas to sink in with us. And if you just race through it, what did she say? What did he say? So work with each other and doing it and practice. You know, for those individuals who have very soft voices, appreciate you have a soft voice, but we want to hear what you say. So get close to the mic, speak loudly, expand your chest, and speak out so we can hear you. Now, you never probably expected to hear any of this, but I've had a lot of experience in this. Take it for what it's worth, and I hope it's worth something to you. Thank you.
Thank you. And with respect to the rest of the agenda, at 1 o'clock, we do have an additional witness who is only available from 1 to 1:30. So at 1 o'clock, whatever it is that we decide at 12:15, at 1 o'clock, we will have an additional witness. And I believe that's on Zoom, right?
Correct. He will testify on Zoom, Mr. Chairman, and I would just note for the staff instruction, well, for the commission as well, we will technically remain in public session while commissioners get their sandwich to return at 12:15. So we can simply, if Shara and Ashley, if we can put up the slide that the meeting will resume shortly, but continue the recording, that will be just fine. So commissioners, we remain in public session while you quickly grab a sandwich from behind you. And I guess then in accord with the chairman's instructions, we'll reconvene at 12:15. And certainly for members of the public, you're obviously more than welcome to remain and stay as long as you want into the afternoon. We have one more witness at 1 o'clock. Thank you.
Missed that.
Yep.
Yeah, we have the public comment. Yeah, well, yes, I guess.
Yeah. All right, the time is 12:15. We had represented, we'd come back into session. It seems to me it makes logical sense. We take we had 12 witnesses or I'm sorry, 12 public participants who were waiting. Seems to me it makes sense that we take the first 12 as we reconvene. So I'll turn it over to the executive director and let's get our first additional public speaker.
Okay, so we will now, thank you, Mr. Chairman. We will now move to remote public comment. Again, for members of the public who have indicated a wish to make public comment, you will have 3 minutes to make your comment. Commissioners will be able to hear you but not see you while you make your comment. And we have extended the public comment period, but we'll be unlikely to get to everyone who is in the queue, but we will get to as many as we can. Please stick to the 3-minute limit to allow as many people as possible to make comment. Ashley, can you go to the first speaker, please?
Yes. First off, we have Kevin Johnson. Kevin, I'm now turning on your ability to mute yourself.
Mr. Johnson.
Thank you very much, Mr. Chair and members of the commission. I'm a CEQA practitioner, and I've been carefully listening in on all of your hearings. And I have a way forward for you that I would like to recommend, looking for common ground on how to make CEQA look better. You heard some suggestions today talking about burdens of proof and attorney's fees. Those are provisions which would kill public advocacy through CEQA. So please beware of those things. I was the member of a working group in 2018 and 2019 of lawyers from around the state who their practices represented environmental groups, environmental justice groups, lead agencies, and developers. Mr. Moose was a member of that working group. And after 18 months of meeting once a day, often for 10 hours a day, we came up with a series of proposals that found middle ground, if you will, between all of our various perspectives. And they were focused on making CEQA work faster and more efficiently. You have submitted as part of your record a CEQA 2.0, that was the name of the effort, amendment chart. And it has provisions in there with specific language that has been developed and approved by Ledge Counsel and was introduced as Senate Bill 950 that includes record preparation streamlining to save a lot of time, CMC procedures which expedite the processing of the litigation, tolling agreements to facilitate settlement discussions, pre-hearing settlement meeting requirements to encourage settlement of a case early on, and then something of particular importance based on what you were hearing today, a series of changes which would increase CEQA expertise. It would facilitate prompt hearings, timely decisions, the reduction of the number of CEQA appeals with uniform application of the law. So a central theme you heard today, and we've heard it coming forward from a number of people, is we need to move things forward. Mr. Selmi agrees with that. I agree with that. Our 12 lawyers that were part of the CEQA 2.0 effort all agreed with that. One important point too, in connection with this chart, which I asked that you all review, we had estimates about how long cases would last. And in the chart, we estimate that your average CEQA case lasts about 9 months, maybe a year. The bigger ones last maybe 20 months or a bit longer. And there are outliers that will go 6 years. I would submit that Mr. Manley's cases were probably all pretty big cases. So you need to have a realistic impression, understanding of where things start right now and how long they take, but then look at 950 and it will show you a way, because we might.
Mr. Johnson, your 3 minutes has expired. Please wrap up quickly.
By definition, 2.0 effort found common ground, which is what I think you all want to do. So thank you very much for your time. And Chairman Nava, thank you so much for leaving time for us to talk.
Thank you. Ashley, if we can go to the next speaker.
Thank you. Next, we have Lynn Plembach. Lynn, I'm now turning on your ability to unmute yourself.
Sorry, it doesn't. Oh, there we go. Sorry. Lynn Planbeck, I'm with Santa Clarita Organization for Planning and the Environment in Northern Los Angeles County. And I just wanted to say how much I appreciate the previous law student speakers. I think each of them brought an individual aspect of how CEQA has improved our lives. And I'm speaking from a community activist point of view. I'm not an attorney, so I may not be as well spoken. So I very much appreciate their comments, which I agree with. I just wanted to say that it did seem that Mr. Tangri was arguing a case he lost, which was the Freon one before you, and without you having the opportunity of hearing the other side. So again, I appreciate the law student bringing up the other side. And it seemed like the majority of your expert panelists were advocates for the development community, which I think is less concerned with the well-being of the public and more concerned with their bottom line than is maybe helpful. And that's why CEQA is so important, even though it may cost a little money and it may make the process a little slower. Understanding the full import of all the impacts on the community is really, really important. And the only way that can happen is through our CEQA process. The one thing I think is missing is that, you know, many agencies have used this process also. Our city of Santa Clarita opposed a landfill, which it turned out would have been quite a terrible thing in light of what's gone on currently 20 years later. It was opposed because it was over the watershed of our drinking water source, which I don't know that anybody was anticipating how short we would be on water, but thank heavens they did this and did not cite that landfill. It would have also cut down 3,000 oak trees at a time when we are now realizing how important trees are to sequestering carbon. I just want to make sure that you all are aware that agencies use this to protect their communities as well. And I really haven't heard that point of view spoken in these projects. And I don't know if Senator Wilk joined you, but he is my senator and I have been in to talk to him about these issues. And we have also a large Cemex landfill, Cemex gravel mine, that it's really important if they are cited in their location that they protect the schools and everyone from air pollution. So it's just a really important law, and I hope that you will be really, really careful if you're going to tweak it at all. Thank you so much.
Thank you, Lynn. Next, we're moving on to Adrian Gladson. Adrian, you should now have the ability to mute yourself.
Good afternoon. I am Adrian Gladson, members of the commission and chair. Thank you for more time to speak to you. I thought I would share with you the perspective of being a practical CEQA user. I'm a retired city planner in Orange County. I reside in Orange County. I'm a certified city planner for 27 years. It's my professional opinion that CEQA works. And I wanted to give you perspective of some of that. I sent you a letter dated May 10th. I'm not going to read it to you, but I wanted you to understand the reality of being a public planner working in the trenches with applicants and developers, be it housing developers, affordable housing developers. There's a lot of myths connected to CEQA. There's a lot of information that's not characterized correctly. I would suggest that you take a look at perhaps when you do your report, look at some triaging of some of the needs related to what you've been asked to tackle. In my experience in my career, I only worked on 3 EIRs, and 75% of my projects were exempt from CEQA, and none of them were CEQA challenged. None of them had a lawsuit connected to it. So as many of your speakers have shared with you, most of the cases that get in front of a judge or a court are not litigated. And I think that needs to be reflected in your findings when you prepare your analysis. Second, I wanted to share with you that I was a planning commissioner previously for 8 years. So I was in the role as a decision maker, and CEQA was the tool I needed to know the information, the data points, the thermometer of environmental issues. It gave me that background, and I went there first before I could make a decision. So I needed that information, and I would submit to you that all decision makers in California need that data, need that neutral position of what CEQA provides you, either an EIR, mitigated neg deck, and the community, because we want to be transparent about that decision-making process. If there are influences that might be pressuring staff to go a direction on a CEQA document, the public has an opportunity to cry foul. If there's wrong information that's included in the document, it can also be raised. So I would also share last with you, the public process, as I'm not an attorney, but CEQA gave me the tool to negotiate even before the project went to public hearing. I could tell an applicant, walk an applicant through the process of what they might be facing. And I will share consistently. It got better.
Ma'am, your 3 minutes has expired. If you can wrap up quickly to allow other people to make comment.
I'm happy to do that. I just would final thoughts is I think it's good for you to triage and come up with a nice report that covers all the elements, both exemptions, neg decks, EIRs, and then take a look at whether there really is a ton of litigation at the local level.
Thank you.
Thanks.
We can go to the next speaker, please.
Thank you. Our next speaker is going to be Jesse N. Marquez. You now have the ability to unmute yourself.
Hello, can you hear me all right?
We can.
Okay, my name is Jesse Marquez. I'm a community resident of Wilmington and the founder and executive director of the Coalition for a Safe Environment. We have membership in over 25 cities in LA County and over 9 states in the United States. What has been a big disappointment in listening to all your expert witnesses is that none of them really complied with the intent of today's meeting in regarding judicial issues. So let me tell you what we have learned about the role of the judiciary in CEQA. California CEQA Superior Court judges are prejudiced in favor of government agency infrastructure projects when public CEQA lawsuits are filed. They violate their fiduciary responsibility to be unbiased and to perform their due diligence to confirm that all CEQA EIR requirements are complied with. In 2001, a CEQA lawsuit was filed by Natural Resources Defense Council and several San Pedro homeowners associations over the China Shipping Container Terminal project. The Port of LA project was approved by the Director of Management, the City Attorney, the Board of Harbor Commissioners, and the Los Angeles City Council. In 2002, the Superior Court of Los Angeles County judge ruled against the plaintiffs in favor of the City of Los Angeles and the Port of LA. The plaintiffs filed an appeal. On October 30th, 2002, the Court of Appeals issued the following disposition. The judgment of the trial is reversed. The matter is remanded to the trial court with the direction that it grant the petition for writ of mandate and order the port to prepare an EIR in connection with all 3 phases of the China shipping issue and to issue an injunction incorporating the terms of the stay of issue. Some details. The Port of LA was so arrogant and above the law, they did not even prepare a project in EIR as required by CEQA. They claimed the project was covered by 2 previous EIRs, which was the 1997 West Basin Transportation Improvement Project and the 2000 Port of LA Channel Deepening EIR, which never mentioned the China shipping. The Court of Appeal also issued an injunction to cease and desist all construction of the China shipping terminal, which was 80% complete. The Port of LA was so arrogant, they continued and went 24/7 thinking that if they did lose in court, no judge would stop the project or require them to tear it down. On March 2003, the city agreed to a $60 million settlement with environmental and community organizations. To answer your other questions, challenges that CEQA cases may pose for judges. Number 1, there is extreme shortage of CEQA judges, which causes significant delays in hearing cases, case research, and in making final decisions. New CEQA judges have little court experience, which causes significant time delays in hearing cases, case research, and in making final decisions. Judges are prejudiced in favor of government department infrastructure projects when public lawsuits are filed, which causes more appeals to be filed, which causes significant delays in hearing cases, case research, and making final decisions.
Mr. Marquez, your 3 minutes has expired. Please wrap up to allow other people to comment.
Yes, I've also emailed you a copy of all my written comments, which are 5 pages long, which do address the judicial questions that you asked. And thank you for this opportunity.
Thank you. Sheriff, we can move to the next speaker.
Thank you. Our next speaker is going to be an email address. It includes CT Williams 2012. You now have the ability to unmute yourself. CT Williams 2012 at yahoo.com.
Go ahead. You're still muted, so unmute yourself, please, if you wish to make comment. Sure, I think let's move to the next speaker.
Okay, our next speaker is going to be Mike Lainez. You now have the ability to unmute yourself.
Good morning. Can you hear me?
We can.
Great. My name is Mike Lyons. I'm the Director of Public Policy for Audubon, California, the state office of the National Audubon Society. We have 48 chapters located throughout the state that frequently engage on local planning and development. As an attorney who has been involved in CEQA cases as a litigator and as a client, I really appreciate Little Hoover Commission's efforts to hear from all sides and your comprehensive hearings. Before I begin, I do want to second the concerns raised by Jonathan Pruitt regarding the governor's trailer bills and concerns about the reforms that they propose through the trailer bill process. I want to start by emphasizing that the environmental stakes of CEQA reform are very real. Prior to CEQA, as you've heard, development in California left our natural environment in wreckage and placed undue and unjust burdens on disadvantaged communities, communities of color, and tribes. Permitting agencies did not protect people and habitats. Citizens had few ways to engage in development processes that were really run by developers. And as a result of this kind of rapacious development process, over 600 California species are at risk of extinction today. We've already lost 90% of our wetlands and coastal sage scrub habitat, and we've degraded millions of others of acres of habitat. Even since CEQA was enacted, we've continued to lose biodiversity, including over 1 million acres of natural areas in the last 20 years. And these threats will only escalate with climate change and continued development. So this is not a time to roll back environmental protections. For the most part, the attorneys and developers advocating for CEQA reform are pushing for rollbacks that move us closer to a pre-CEQA California, with fewer protections and less public involvement and oversight in the CEQA process. Developers will make more money, but the environment and certain communities will suffer more. This does not mean that we don't continue to build housing and renewable energy projects or even sports stadiums. Audubon supports well-planned projects to safely house people, provide essential water resources, meet renewable energy goals, and other economic goals. But it means we can't circuit the process to maximize profits and convenience for developers. Any changes to CEQA must come with increased environmental benefits and public health protections. In practice, I want to be clear that in practice, issues like the power imbalance between developers and community groups and regulatory capture by developers of counties is very real. Counties are often involved with project developers that they are supposed to regulate and are often under-equipped to understand the cultural and public health and environmental impacts of projects they approve. And they must rely entirely on developers and the developers' consultants to identify the alternatives, impacts, and mitigation measures. Overall, the political and financial pressures are very real to shortchange the environment and communities to appease developers and political interests. So as you consider recommendations on ways to improve CEQA, I urge you to keep in mind that for many small community groups, CEQA is their only opportunity to substantially weigh in.
Mr. Lyons, your 3 minutes has expired. Please wrap up quickly so other people can comment.
And just given our ecological debt and environmental problems, any changes to our environmental laws should ensure net benefits to the environment and protecting vulnerable communities. Thank you.
Thank you. Sheriff, we can go to the next speaker.
Yes, our next speaker is going to be Carlisle Ann Young. You now have the ability to unmute yourself.
Thank you. I found it. Yay. Just like the last speaker, Mike Lyons, I have a concern that my county will approve a housing development in San Mateo County. They are creating their own EIR for the developer, and they'll obviously approve it, even though in the preliminary report that I saw, the project would put existing stormwater into Montera Creek, which then flows directly into the Fitzgerald Marine Reserve, which is an area of special biological significance. It concerns me that they are being pressured by the mandated California housing element to speed up approval and ignore sea creatures and fire evacuation. And also they're brushing aside the ingress and egress on Highway 1. So in the effort of environmental justice, somebody else mentioned earlier, the people of color where developers are building on toxic land. This also, the property I'm concerned about is a former military site. So like Hunters Point shipyards in San Francisco, where Tetra Tech falsified the soil testing for radiation, but only after a whistleblower made this known and the buildings had already gone up, did it come to light. So finally, I just want to mention that the Gannok Valley development, 1,400 acres of boutique luxury hotels and villas and golf courses, and polo grounds, which the developers made some concessions recently because the judge ruled against their lack of wildfire risk and evacuation safety. So and that's in the Middletown area of Lake County, which of course is fire prone. So I think it's important to be able to have at least some other alternative when the county just rams it through, because in Lake County, the Board of Supervisors approved it. And it was only because of a Superior Court judge that they pushed back and said that they needed to decertify it until they could go ahead and figure out better fire evacuation for the 4,000 residents, new residents that would be added to a population of already 10,160 residents. So that's all I had to say. I don't really have any comment on whether or not you have your own judicial court, except to say that the Sackler family, which made oxycodone, they hired their own FDA expert after he had made sure streamline their approval process through the Federal Drug Administration. So it's not always the best thing to have the insiders running the game. Thank you.
Thank you. If we can go to the next speaker, Sharon.
Thank you. The next speaker is going to be Jonathan Friedman. You now have the ability to unmute yourself. Jonathan Friedman.
Mr. Friedman, if you can unmute yourself, begin your comment. Cheryl, let's go to the next speaker.
Okay, our next speaker is going to be Rick Cotes. You now have the ability to unmute yourself.
Yes, my name is Rick Coates. My apologies, my great granddaddy wasn't a good speller. Commissioners, CEQA is not responsible for the judicial delays in projects. The real reason, the reason projects are delayed is that some cities, counties, state agencies, private corporations, and developers simply refuse to follow the law. That is what forces the public to intervene to enforce the law. In their avaricious pursuit of maximum short-term profit, some project proponents consider the environment and the local people that live near their pet projects expendable. CEQA empowers residents to protect their local values and environment. CEQA is democracy in action. Perhaps that's the reason why so many corporations and so-called developers hate it. This commission should not recommend that CEQA be weakened. Rather, it should recommend that it be strengthened. And then this commission should turn its attention to the real problem. The reason government agencies approve bad projects for the developers. It is our corrupt, anti-democratic campaign finance system. It's actually legalized bribery. It's the reason that our governor pretends to be concerned with the environment, but grants new permits for fossil fuel projects, protects the abuses of PG&E, allows the Public Utilities Commission to attack solar power, promotes logging methods that increase fire danger, and now seeks to weaken CEQA. Commissioners, please recommend strengthening of CEQA. Thank you.
Our next speaker is going to be Lionel Meyers. You now have the ability to unmute yourself.
Yes, good afternoon, commissioners. Thank you for allowing me to speak. My name is Lionel Meyers. I'm a resident of Sun Valley, Los Angeles, California. I'm a board member with the Sun Valley Area Neighborhood Council. I'm here speaking as an individual. I would like to comment about the CEQA and the environment. As a wildlife and environment advocate myself, I feel strongly that we should protect public lands from further land development. I understand in Los Angeles, we have a housing crisis throughout the state of California. The homelessness is linked to the cost of housing. But in Los Angeles, we have an overdevelopment. And there has been, for example, in the Santa Monica Mountains, this past Monday in LA City Council Plum Committee, we were able to persuade the Plum Committee to pass a wildlife ordinance district to protect public lands from further land development in the Santa Monica Mountains, because the wealthy want to build a resort, a hotel, and we are opposed to it. And we feel strongly that we should utilize tools that we need, like such as CEQA, to protect public land, to protect wildlife, the monarch butterflies and the mountain lions and the deers and native species, because they are threatened with climate change and with land development. And I understand that we have a housing shortage, but in Los Angeles, it is overdevelopment, and we need to utilize every tool necessary to protect underserved communities from exposure to oil drilling, gas drilling, and destruction of our parks, our San Gabriel Mountains, and we have to protect, the LA River. And because these land developers, they could care less about the impact it has on low income in neighborhoods and wildlife. So those are my concerns. Thank you for having me here. I yield the balance of my time. Thank you.
Thank you. Our next speaker is going to be Ovita Mendoza. You now have the ability to unmute yourself.
Good afternoon, everyone, and thank you for letting us speak on Zoom. I wasn't intending on speaking on this call, but after listening, I felt compelled to. I am a first-generation Mexican-American, born and raised in East Oakland, and I was the lucky child who played on a park on 98th Avenue in Bancroft that years later come to find out was a battery waste site and had to be closed down and cleaned up. Those are the things that CEQA does today for us. It protects our children, it protects our residents to ensure that they live in healthy communities. And again, it does impact people of color the most. So I don't think we're here to talk about weakening CEQA, but I do not feel comfortable with having selective judicial placements for CEQA. I have really big concerns about special interests. I mean, we just saw as Glazer put through 1439 because we know there's pay to play, and I'm sorry to say we do see it happen. So I wouldn't want anyone dedicated to CEQA that could be lobbied for projects. The other thing that was interesting on this call is we keep hearing that we're having a housing crisis. Well, we're not having a housing inventory crisis. We're having a housing affordability crisis. If we look at areas like Los Angeles, they have about 28,317,000 Airbnbs. They have about 244,614 vacancies per the census. So we have plenty, and they have 69,000 homeless. So we have plenty of units. So this idea that we need to keep building more is kind of being pushed by developers because they want to make money. The other thing is Mr. Moose actually concerned me a little bit with his comments. He talked about margins for developers. I don't see our role as protecting margins for developers. Our role should be protecting the people from negative aspects to any single project. I think that's important. And so those are the big things that I wanted to talk about. And I hope that we don't make a dedicated judge for this. I hope that we protect CEQA because it's under attack. It's over 100 housing bills since 2016 that attack CEQA. The latest one that's in the legislature moving through right now that looks like it's going to get passed is SB 423 that removes CEQA, that removes coastal protections, that reduces affordable housing requirements from 20 to 10%. So this narrative that the legislators care about housing and want to build housing is a complete farce. And we actually need to look at their donors and who is actually pushing for this judicial process and system set up, because I don't think it's for the people. I think it's more for the developers. And lastly, if you don't believe that they're making money, any publicly traded developer, you can look at their P&Ls. They're all making 20 to 30 points depending on the developer. And we're looking at price gouging with oil and gas. Maybe we should be looking at price gouging on housing versus actually giving them free rein to do whatever they want and hurt our environment. So thank you so much for your time. I appreciate it and have a good afternoon.
Thank you. Our next speaker is going to be John Murdoch. You now have the ability to unmute yourself. John
Yes.
Murdoch. Thank you. We can hear you.
Okay, thank you very much for having the public this opportunity to address you. I've been listening. I've listened to several of your sessions. I am strongly opposed to a specialized court because of the captured agency phenomenon. I can give you one good example of that, and that is with respect to emissions from EMF devices that the FCC was supposed to be regulating. And a case went up to the DC Circuit in Washington, where the petitioners proved that the FCC hadn't updated their research for 20 years. And that's why they were giving a pass to harmful radiation devices. So I've been a CEQA practitioner since 1975. I'm now retired, so I can't claim to have any stake in what you do, except that I'm very concerned that you will weaken what is a very good law. I think you need to listen to the public comments much more than, unfortunately, Mr. Moose, who admitted to having been a progressive from Berkeley, but turned over the years of representing developers into an advocate for, speed, margins of profit. And this is what happens to all of us as we age. We become conservative, protective of profits, and you should really pay attention to the young law students that were courageous enough to speak in spite of their lack of experience. From my 40, 50 years of experience, I think that you have to very seriously stop the weakening of CEQA. It's a serious concern because we have to protect the environment or else suffer the consequences, which are disastrous. The developers are generally corporations. Corporations have been granted by law a perpetual existence. They never have to go out of existence. So they have the time They have the money. If they have a good project, it will eventually be approved. The courts will approve it. The public will accept it. If it's not a good project, it's going to take a long time to get through the court system, and that should be just as it is. I
Sir,
encourage
your
you-
3 minutes has expired. If you can please wrap up quickly to allow others to comment.
Thank you. Please pay attention to the public comments today. They're very important. Thank you very much.
Thank you. Sheriff, we can move to the next speaker.
Thank you. Our next speaker is going to be Lynette Lee Eng. You now have the ability to unmute yourself. Lynette Lee.
Yeah, hear
Eng.
me? Can you hear
Thank
me
you.
now? Okay.
Yes, we can.
Thank you so much. Okay, my name is Lynette Lee Eng. I'm a council member for the city of Los Altos, but I'm speaking on my own behalf. I greatly appreciate the time and the opportunity to listen to all the additional speakers that exceeded the half an hour. I would like to say that we must not forget the reason and purpose for the secret process: to identify potential environmental impacts and achieve environmental compliance. We should not be doing less, but working more to strengthen the need for the compliance and further protections of CEQA, like all the other speakers had advocated for. This is a process that should not be rushed. The concerns also raised by earlier speakers. It is important that we protect California's unique and diverse environment by ensuring that projects are carefully evaluated. I cannot emphasize how critical it is to have public hearings regarding hazardous waste cleanup. An example in a nearby city near me is the Valco SB 35 project, where they bypassed the CEQA and process, and the public had no input into the hazardous waste cleanup. CEQA is imperative for having public input into the mitigation process and to ensure that the public is made aware of health and safety impacts. There are many cases where a full EIR should be conducted and MMDs are not in the best interest of public health. There are very many environmental effects by carbon microplastics from facilities and operation that many local authorities are saying they are exempt from any review. There should also be a full EIR conducted for wireless ordinances as well. There are human and non-human effects that, if being ignored, is very concerning. CEQA requires that these be identified, quantified, eliminated if properly mitigated. I would be concerned about having a specialized court, much like what is happening with our current legislation process. The direction of one size fits all, or this one rule of thought, is not the best interest of CEQA cases. CEQA needs to be looked at and studied on a case-by-case basis. And I would hope that we continue to question how we do this in a more, sorry. Thank you so much.
Thank you, ma'am. Your 3 minutes has expired. Mr. Chairman, with that, we have taken all of the people online who requested to make public comment. We have one person in the room who was gone earlier, Diana Cruz, and so we'll now take her public comment. I believe the mic is now on. So Ms. Cruz, you have 3 minutes.
Yes, thank you so much for the opportunity to speak. I apologize I wasn't here earlier with my colleagues. I'm sure we've all been pulled into meeting after meeting before, but I really appreciate being here. So good afternoon. My name is Diana Cruz. I'm a legal intern with Communities for a Better Environment. I'm in my second year at the People's College of Law. So I'm here today to emphasize the importance of CEQA for environmental justice communities. And it's without question, right, that low-income communities are disproportionately impacted by environmental hazards and pollution. CEQA is one of the few public participation tools that impacted communities can utilize to ensure that their concerns are considered by providing important information and transparency for proposed development projects on top of contaminated land or adjacent to sources of pollution. Without CEQA, these communities, and these are communities that already have very little political power, will be further disadvantaged by not having a say in local land use decisions that will directly impact their health and quality of life. Streamlined policies without environmental review have many unanswered questions. How might a community advocate for their interests if they are not even aware of potential impacts? How might community members call for mitigation measures when they are not made of potential environmental impacts? How will lead agencies be held accountable? How will legal protections and remedies through the court system be ensured amid environmental harms and inequalities? The answer to these questions does not lie in streamlining projects. Vulnerable communities deserve access to not only affordable housing, but healthy housing. Infrastructure development needs careful consideration, and vulnerable communities deserve to be prioritized rather than silenced, as they historically have been. We must engage in careful deliberation about where a project will be constructed, how it will be constructed, and ultimately whether these projects should be constructed at all if sufficient mitigation is not possible, especially if construction is at the expense of low-income Black, Indigenous, and communities of color. Thank you.
Thank you very much. Mr. Chairman, we have then concluded the public comment portion of the agenda. Judge Reiser is in the meeting, and so perhaps we have texted him to make sure he's ready to go. We're 3 minutes early. We don't have a response yet. But we are trying to find out if he's ready to go now. So yes, I'm told that he is. So we will now be able to take Judge Reiser's testimony. I'm going to be extremely brief in my introduction, Mr. Chairman, because I know Judge Reiser has a hard stop at 1:30. Judge Reiser was a Ventura County Superior Court judge and was the CEQA judge in that county for more than a decade. He has received many judicial counsel assignments in CEQA cases, including those related to LAX master plan, various Kern River issues, and water banking within the Central Valley. He is extremely knowledgeable about CEQA, and with that, I'm going to turn it over to Judge Reiser. Judge Reiser, if you can, is he able to unmute himself?
So I'm Judge Glen Reiser. I appreciate the invitation to be here today. I also want to extend my appreciation to the commission members for your service.
Judge, we are not able to see. No, we're there. There we are. There we are. Now we can. Thank you so much.
You have
Go
to
ahead, sir.
see Century City skyline behind me. So, but with that, so before I became a judge, and I was a judge for more than 20 years, I did have a very expansive background as a CEQA attorney, litigation attorney, though also, on the planning side of it as well, as projects progress through, whatever county, local agency, special district was the lead agency. But in all of my years as a judge, I never encountered another judge who had that kind of a background. And I did have a lot of statewide assignments and encountered, there's probably 2,000 judges in the state. I probably knew, more than half of them. And so ultimately, as a judge, when I was assigned the CEQA calendar, ultimately for more than a decade, I was a bit of a freak, right? A unicorn, if you will. And once the administrative record was certified, which is often a time-consuming task, it became like a kid in a candy store. Court calendars are busy, so I would take it home. I'd open up the flash drive. I'd read the administrative record, whether it was 5,000 pages, 10,000 pages, 20,000, 50,000, sometimes in the many hundreds of thousands of pages. And I would, I'd walk through the application, the initial study, documents, the scoping before that, the draft EIR, the comments, any recertification matters, recirculation rather, response to the comments. And I actually, as a judge, because the resources are available typically, instead of just reading the hearing transcripts, I would actually watch the hearings themselves, so I could get a better sense of the dynamic at the administrative level. And then I would write my opinions, right? And I think I sent at least one of I went online to see if there were samples, and I found one. But getting to the inquiry that was asked, CEQA cases are really a poor fit for a trial court because for two reasons. First, the size of the administrative record, which when I did the LAX modernization case, right, the current construction, the record was more than 1 million pages, right? You cannot expect a trial court judge in California, even though the Chief Justice allowed me 4 months of full-time work to accomplish that. Just in a standard situation, you can't expect a trial court judge to have the incentive, like I did, the background, the appreciation, know what to look for, and to make that kind of a deep dive. It does not work very well. And then when you layer on top of that the nuanced legal issues, which are unique to CEQA, right? The standards are unique to CEQA. The concepts are unique to CEQA. Not everyone, looks at a CEQA transcript as like the Discovery Channel, like I do, right? It's a deep dive into geology, into hydrology, air emissions, you name it, biota. It's all there, and so it is a very difficult navigation for most judges. The judge that preceded me on the CEQA calendar, before my tenure, my decade tenure, and the judges who followed me, none of them liked it. They didn't want to do it. They thrust it off on research attorneys who also don't have the background or resources. And I do appreciate that there's a 3-day class that I attended, which talked about the basics of CEQA. But it really, you can't in 3 days or even 3 weeks push an entire land use paradigm upon, either an attorney who sits in a research assignment or a judge. And so when I looked at the inquiry that was presented the other day to me, I am of a mindset that the state of California really ought to have a standalone statewide CEQA court. And that court would have full jurisdiction on all CEQA matters. It ought to have the ability, for purposes of efficiency and economy, to cull out the CEQA case and to remand to whatever county any non-CEQA counts that are part of a complaint, because quite often people throw in the kitchen sink. And with the ability to, obviously every case would be deemed complex, but to cut through what are typically, year-long pleading challenges. I also concurrently ran a probate calendar for more than a decade. And I refuse to hear demurs. I go, yeah, if there's a case dispositive issue, like limitations or standing, which in CEQA are common arguments, you just bifurcate it, try it first, and you don't spend all this time, money, aggravation, and effort talking about what is properly or isn't properly pleaded. Same with summary judgment, summary adjudication. If it's case dispositive, bifurcate it, have it heard up front, and then move on to it and get to the heart of the matter. So if you had, because really it's a workload reallocation, right now all the CEQA cases are dispersed to the 58 counties, anywhere from Modoc to Imperial, right? And so it could wind up anywhere, almost invariably with a research attorney or judge who does not do it for a living or regularly even. And so then it gets pushed to an appellate court, which likewise has commitments and obligations And while they have transcripts, that these are very, very formidable administrative records that are just massive. Almost, more than a death case, if you want to analogize it to appellate matters. And so my thought was, have a staff of CEQA lawyers who are the research attorneys, right? Take that caseload out of the trial court and appellate system, push it into the statewide court. The thing that I think is actually more controversial is, why do you actually need an intermediate appellate court on these issues, right? Why not make the CEQA court the arbiter of these issues, subject to a right of review in the state Supreme Court, just as any other case which comes from an intermediate appellate court would have a right of review. And I say that because the standard of review on appeal in CEQA cases is de novo. So you're basically saying, let's, instead of having one court, let's just have two courts decide the same exact issue, using essentially the same exact standards with a caveat for substantial evidence, things that are not usually necessarily dispositive. And so having said all that, in my 5 to 7 minutes, I think it's a better look. The time it takes to manage a CEQA case would be hugely diminished. You could have professionals who are working on this full time, who know the subject area. They know how to read an administrative record. They know what to look for. They are engaged and not deterred from, an onerous assignment. And so, if you want to know if there's a better way of doing things, of course there's a better way of doing things. It just would require the state to think outside the box a little bit.
Thank you. Let me turn to the commissioners to see. This is Pedro Nava. Thank you, Your Honor, for joining us today. It looks like Commissioner Garcetti has his mic on.
I do have it up. Good to meet you, Judge.
Pleasure.
Thank you. This is obviously a very complex and very controversial subject. And I'm not just talking about CEQA, but I'm talking about having mandated courts, special courts here. In the evolution of courts throughout our history in the nation, we have seen politicization of courts at various times at the highest level. And if you look at today's Supreme Court, I think there's no question what's going on there gets the attention of many people because of their politicization, at least apparent to those of us who are affected by it. If we were to go forward and recommend something like you have suggested to us as a way to move forward, how do we protect ourselves? How do the people who are interested in this, both sides, protect themselves from that politicization that could take place here? I mean, here you have a case where you have one judge who may ultimately have the power to hear it and handle the appeal, whatever, with, okay, it's the final, it's over. But one, how does he or she get appointed? Two, is there a preemptory challenge for a judge? Let's say there are 3 judges assigned to Los Angeles County. I don't know if that's too many or too few, but regardless. All right, does either side have a preemptory challenge? So, okay, no, this judge has been for the last 5 years, he has never, or she has never ruled on our side. So, I mean, how do you handle those practical issues?
Fabulous question. Thank you. And that's a thought-provoking question. My assumption was when I suggested we have a set-aside CEQA court, it would not be one judge. I think it would have to be a panel, right? And our appellate courts now, as you know, have typically panels of 4. It doesn't necessarily have to be 4, of which 3 are the sitting members. Could be 5. It could be 3, right? Head count is always important with respect to the economics, but it's the same issue we have now, right? Yes, in a trial court, you have a chance to disqualify somebody, but if you have a trilogy of decision makers on a panel, right, that one is still a minority. So I think if you're going to have a statewide court, right? Not specific to Los Angeles County. They might sit in Los Angeles County, they might sit in San Francisco County, they might sit in Sacramento, but regardless of where they sit or where they travel to, I think the better solution would be to have a panel of judges who would caucus on every case. And yes, it could be politicized. Every appellate division in California, our Supreme Court is at some level, they're all political appointees and they're nominated. Probably thinking it through as I was listening to your question, Commissioner Garcetti, maybe you want to have retention review by the electorate like you do with the appellate court, so that there's at least that check and balance. But it wouldn't necessarily be at a lesser disadvantage than you would have in any, say, appellate panel, right?
That's a good start.
Thank you. Any other commissioners? I don't see any other questions or hands raised from commissioners. Again, let me express my gratitude to you for participating. When I was practicing, I spent a fair amount of time in Ventura County, in front of numerous judges in that bench, and they were all extraordinary, and you obviously have continued with that rich tradition. So thank you, Your Honor.
Could I ask one more question?
Go
if
ahead.
no one else
Yeah,
has?
Commissioner Garcetti has something else.
The training, the education, I mean, you had a unique experience before you became a judge. I don't know if you could point to any other judge sitting in California right now who has had CEQA type experience that you had. My chances are you might know one or two, but certainly not many. Okay,
none.
All right, so the question is, if you have one every other year, a training session for those who want to be trained, that seems to me totally insufficient given the complexity of the issues, number one. Number two, the issue of, all right, do I look at this as a kind of a plum job? I don't work very hard or have to work very hard. And you look, once you become this kind of a judge, you realize, whoa, what have I gotten into? Because it's really a very deep, long day every day. And you're smiling, nodding your head, yes. So I think we all know that. But there are just practicalities here. I mean, how much training should they have? How regular should that training be? Should there be a review of the decision-making process for this panel so that the communities that are affected by this, and I'm talking about on the commercial side as well as the homeowner, how can they be assured that this is being handled in a fair way by people who really understand and know what the law is and what the legislature intended?
And that's also a great question. The answer to that is really, it's within CEQA itself, right? Because the purpose of CEQA is a protocol and an informational document. To the extent, and what happens, of course, especially in some of the smaller special districts, is there gets to be such a bureaucratic momentum behind a project that things get overlooked in the rush to approve. But the local decision makers under CEQA, their discretion has to be respected, right? That is a fundamental principle of CEQA. It's just whether the document itself satisfies the requirements in terms of accuracy, completeness, honesty. And so as long as the process is respected, quite often I would see, local agencies, small agencies, just bend over backwards to find a significant impact isn't significant, right? And they would do tortuous logic to reach that result when all they had to do was say, this is a significant impact. Okay, and here's the mitigation that we can use to assist with that, but it's still significant. So we'll just issue a statement of overriding considerations. That is a perfectly appropriate way to make a local decision, and that's perfectly, and if you accomplish that under CEQA and you do it in the right fashion with all of the public disclosure requirements, you know, all of the comments addressed, everything that goes into the local decision making, and CEQA respected, the local decisions have to be honored. It's not the job of a CEQA judge or an appellate panel to usurp local decision makers. It's only their job to make sure that CEQA is respected and that the information that needs to be in the document is in the document, and that the conclusions are not something which are ad hoc or arbitrary. It's drawn from the document itself. It's a fairly robust system without overriding local decision making. And so the answer, and I know it's a bit of a roundabout, is that CEQA answers that question because it's not the job of this court to be a super decision maker. It's the job of this court to respect the protocols of CEQA.
If no one else has a question, I'll
have
follow
one.
with one more.
Go ahead, though.
Okay.
Finish up. and then-
Let me just,
Perfect.
put this, special court idea away for now, or you can keep that. But if there is one thing that you would hope the legislature would change in the CEQA law and that the governor would sign, what would it be?
So in addition to having represented project opponents and project applicants and public agencies, right? The problem is the time it takes on a project from cradle to grave if there's a bona fide CEQA challenge. And so there really needs to be amelioration of the legislation to streamline the litigation, to minimize the pleading challenges or just negate them, to let the court get to the heart of the matter. And when you add an appellate court and a CEQA record, you're adding at least 18 months to the project itself. And so CEQA opposition itself can be a project killer by virtue of the time delays. The discovery process, with privilege logs and everything else can use another year of litigation in the trial court beyond pleading issues. And so there needs to be a way within the current paradigm to push the matter directly to resolution without a lot of roadblocks. It doesn't benefit anybody other than just somebody who wants to defer a project, a great project or a terrible project, just by virtue of the litigation. That is within the current schematic that needs to be modified.
Thank you. And thank you very much for taking the time sharing this with us. I know there's another question.
So, Your Honor, thank you very much for your testimony today. I greatly appreciate it. I'm interested in your view of a couple of questions that we heard today. One is inconsistent opinions throughout CEQA, and also activists or judges stepping in where the legislature hasn't actually defined particular studies or how particular things should be done. And I'm curious of your views, and then taking this full circle, your views of how a CEQA court might address those issues. So is it happening? Is that what you're seeing? And then how would a specialized CEQA court address such an item?
Well, certainly, the concept of a centralized court creates uniformity. I get it. There's a concern about how that uniformity, is how the consistency manifests itself. But the difficulty is CEQA is so formidable, and the standards, while they're clear to a practitioner, right, can be a little loosey-goosey to a court. And there may be a temptation because courts review conduct, they review actions. And when it's purely a court trial, like a petition for writ of mandate on CEQA, courts have a tendency, I think judicial officers have a tendency to want to opine about results, right? And that really runs afoul of CEQA. And so to answer the question, one of the reasons why I think a centralized panel would be more beneficial is you would avoid these completely opposite results that happen within the various ultimately appellate courts, because those are the published opinions that people are looking at. And I think that would create a better solution there. But yes, activist courts are problematic because really the focus is on the process and the integrity of the process and public transparency, right, of the process. And I mean, I represented, developers years ago, right, among my many clients. And the reality is that public hearings under CEQA they're not farcical, but all the work has already been done. People have talked to the decision makers. People have sat, no Brown Act violations, but they've met with the decision makers, project proponents one-on-one. How can I make this project better? How can I get your approval? How do I get your vote? And it's, a lot of times these hearings, which I watched over and over again in so many different contexts, are fates accompli because it's already been decided before there is even, a hearing. Yes, there's public participation in the comments, but people look to a hearing as a vibrant sort of democratic institution. But in the planning world and in the, whether it's a planning commission, a city council, a board of supervisors, a local board, what have you, right? Most of the, all the legwork's been done and the votes have already sort of been pre-counted. It's a bit of an anomalous from a public perspective. And so, that's something I observed over the years that, people would be very vigorous at these public hearings, but, it's a little too late. It's only if they add new comments that need a response and new information that's provided that uplifts those comments to something that requires, a greater and a deeper dive.
Thank you very much.
Thank you. Let me look at the fellow commissioners. I don't see any additional questions. So again, thank you very much for taking your time to share your experiences and your perspective with us.
Such a pleasure. Thank you so much. Good luck with this.
Thanks.
So, Mr. Chairman, that concludes the testimony on this issue. So we have two additional agenda items that we noticed. The commission can take them up now or not. That's entirely up to you. The one is a full commission discussion of potential CEQA recommendations. This follows a request earlier in the process, chiefly from Commissioner Hernandez, but also others, that there be an opportunity for the full commission, not just the subcommittee, to discuss this topic.
Yep.
The second is future topic selection. So, and I think I will, with the commission's permission, Mr. Chairman, I will go to the witness table just to be able to.
Yeah, let me
respond.
take the, all right, if you want to go ahead, Ethan, thank you. But let me find out the pleasure of the commission. Seems to me that we spent, today listening to witnesses and listening to a fair share of public testimony. The report remains in a sort of draft status. There was information contained with respect to possible recommendations. I sense that what staff could benefit from is the expression by commissioners today while we are still on this topic, and then while staff goes out to sort of polish the draft, to hear from commissioners with respect to how they feel about the draft, what it is that they think the draft ought to include, and observations regarding today's testimony. So let me just open that, because I just think that's the more productive way to go rather than shifting gears and starting talking about new projects. All right, so let's start. Whoever wants to offer their perspective in terms of observations and directions to staff, feel free.
I'm going to quickly speak for the subcommittee to say we're very interested in what the rest of the commission has to say in the open forum. We have been debating between ourselves, but because of the importance of this issue, I'm very interested. I know that Commissioner Byer has some thoughts, so I want to make sure that we call on him. But before I really weigh in, that I'd love to, see if others have any thoughts. And I know again that David does, because he told me he wants to chime in. So, but I think, Dion, I don't want to speak for you, but I think through our discussions, hearing from the rest of the commissioners is very important. And I hope also that Commissioner Hernandez maybe is able to also chime in.
Mr. Chairman, I'm told that both Commissioner Byer and Commissioner Hernandez have already raised their hands.
All right, okay, good. So you want Commissioner Byer? Is he available?
Yeah, I'm here, Mr. Chairman.
All right, then please proceed.
Okay, I will try to be succinct. First, I want to compliment the staff on the excellent work, both the staff reports and the 5 hearings and the subcommittee chair and vice chair. This is a daunting topic, and it is both important and fraught. So I'm going to offer sort of one general observation and then specific comments that respond to the options that were presented in the staff memo. I'm not going to go through all of them, but in general, I believe that CEQA poses a great opportunity for environmental justice and needs to be maintained. Second, that democracy is best served when elected officials provide clear guidance for the adjudication of rights between conflicting interests. And to me, that means that we need to be particularly focused on what the legislature can and should do more than anything else. Having said that, I believe we could get better certainty if we had a rational standing to sue rule, something like the National Environmental Policy Act or the New York State statute under a similar CEQA-like rule. But I think the legislature should, at least every 5 years, review what elements belong in an environmental impact review. Things like greenhouse gases should not be added to the list first through judicial action. So I think it's a balanced point. Second, that there should be a stable administrative record that does not need to include unnecessary or immaterial things like random emails that have no demonstrable material effect on the outcome of either the EIR or a permit approval. And that this is in the staff memo, that the models adopted by state agencies should have some validity and a lifespan of at least 3 years so that you don't end up with late changes to models changing what's in the EIR or how it gets reviewed. Next, on attorney's fees, I'm worried that some state and local agencies, because they're not able to collect attorney's fees, are willing to approve projects because they know that the developers are going to pay the attorney's fees for litigating the case on the facts, forcing them or coercing them to approve things that shouldn't be approved. So I believe for equal justice, they too should be able to collect attorney's fees under limited written by statute rules. Next, I think documents should be translated, especially notice of hearings. And then lastly, I'm opposed to specialized courts for the reasons contained in the famous footnote 12, but in favor of more frequent training, better selection of judges for the existing system, and a requirement that the legislature review a summary of relevant case law at least every 2 years to determine whether CEQA should be amended. With that, I close.
David, thank you.
Thanks.
Can I also raise my hand behind Commissioner Hernandez?
How about Hernandez? Right?
He raised his hand first and then I'll go
Fine.
after.
All right, Commissioner Hernandez?
Just want to first also echo in terms of the enormity of the work and the diligence of the commissioners and the staff. I mean, and just looking at the recommendations, I mean, the breadth and depth are there. So my comments is kind of twofold. First, given that there will be a lot of recommendations on this, if there's a way to illustrate to the legislature and stakeholders kind of maybe a short-term, long-term timeline in terms of which ones make sense, the recommendations to do shorter, and also a priority given that we want to address some of the timeliness issues, the efficiency issues, the expertise issues. The second one, in terms of the actual recommendations, I am leaning towards the special courts.
I'm having difficulty hearing what comes in and out.
Commissioner Hernandez?
Yes.
Yeah, you fade in and out. I don't know if that's because you're walking or you're turning your head, but just if there's a way for you to speak so that.
How about now?
Hey, there you go.
Okay, so what part did I fade in and out?
You were on specialized court.
Oh, that yeah, no, I support the specialized court, and then on that one specifically thinking about a way populations are able to participate at the same level. I know that in other areas, I mean, this is more in terms of rulemaking, there's something like intervenor compensation or a program where there's extra resources for certain entities to be able to participate. I do want to look at the whole issue of if we set up certain timelines, how that might impact individuals or communities that have lower or fewer resources. But overall, I do like the direction of where their recommendations are going. And then I would just kind of stress again, if we can prioritize or create some kind of timeline in terms of short-term, long-term.
Very good, thank you. Commissioner Sidley.
First, let me be clear, I'm speaking only for myself, not as a subcommittee. And so we've had very robust discussions and I appreciate that very much. First and foremost, as a CEQA practitioner, I want to make it clear that I do think that CEQA is very important. It has a very important role to play. You know, you should stop and look at what your proposed project potential impacts. And so at no point would I be suggesting that we were to abolish CEQA at any way, shape, or form. I think what we are here to discuss and to make recommendations about is to streamline, improve, and to work on some just some equity, as we've heard testimony from various different people in all sorts of communities that are using CEQA in various manners. So I kind of want to work first with the list that David provided. I do agree that elected officials have a profound role to play. And CEQA was designed through elected officials and should remain there. So the idea of having CEQA reviewed at a particular time frame, 5 years, something like that, I think would be very valuable. Obviously, as the environmental laws or environmental rules are changing and we continue to see new modeling, I think things like that are very important. I also agree with David that models should be in place. I think from the day that you issue an NOP, then you should have some period of time where what you know as somebody who is working on a document remains consistent. There is a situation where you could have been working on a document for 18 months, 20 months, and a new model will come out and you have to go back and start again. And I just think that there should be a time frame of which you have to get your document done in that time, or new model and you have to deal with the new model. So I think that that would be an important recommendation. As for emails, I agree that I think we need to take a good look at the administrative record and what's included and what's not included. I want to make very clear when I'm talking about emails, I'm not talking about public comments. And I understand that public comment comes in by email. That is a public comment. That is not an email that I am talking about when I'm talking about not including them in the administrative record. So I just wanted to clarify that. I agree with Commissioner Hernandez. I think that the specialized court for this area is something that we should look at. I don't think there should be just one state court so much as we should have, it should be of a circuit of sorts. I think it has to cover the state. I think it's important that maybe 4 or 5 of them. I think there should be a broader panel. Commissioner Garcetti, I think courts are inherently political by how judges are appointed. And so how long somebody serves on one of these courts, if they rotate off every 5 years or something, to address that concern. But I do think that given, I'm usually not a fan of a specialized court, because why this over, as you mentioned, domestic violence or something like that. But the CEQA does, I mean, I think as the commissioners have learned and not practitioners, I think you've seen how difficult and complicated this law is. So, or this statutory framework is. So I think that this is a little bit unique. And finally, I want to come to translation. I think that we need to maybe put translation into another bucket and actually study it, because, and there are particular reasons why I say that. What is the jurisdiction? So what languages are you going to use? Is it the jurisdiction of the state? Is it the jurisdiction of your project? Is it the jurisdiction? So again, I'll speak from personal experience. Is it the Port of LA? Or is it the city of Los Angeles? Is it the county of Los Angeles? What languages are you doing? How much time will it take, add to the process to translate? What am I translating? Am I translating the 1,000,000 pages that the judge just spoke of? Am I translating only the statement of overriding considerations, only the notices, only the summary, the executive summary? I don't know. So I think that that needs a deeper dive. And so I would, and again, I don't know cost, I don't know any of that. So I would make a recommendation that we look into that and that we get a real answer and then we make an informed decision. But just to say translation and throw up your hands, I think is not, it's not exactly helpful to where we are in trying to deal with this. I understand the request, and again, I can tell you the Port of Los Angeles, we take hearings in Spanish, notices go out in Spanish, but again, I don't know what the universe is. So I also raise that. And as attorney's fees, I agree with Commissioner Byer that there needs to be, there is bias involved in attorney's fees. So if you don't have both sides having something, skin in the game, you kind of have, you have incentive to sue. And, you know, that maybe isn't the best interest. So those are my thoughts. Again, only my personal thoughts. And I thank you all for your time.
Commissioner Aaron.
And then Mr. Chairman, just FYI, I believe Commissioner Hernandez re-raised his hand.
Okay.
Oh, great. So I want to, first of all, thank everybody who has participated in this hearing process. This is the longest hearing process I think the commission's ever had, at least since I've sat here. And that's because it's an incredibly complicated issue. And I think I've shared with you and many people in the audience that as people come before us, right, to testify, right, we would sit here, or at least I would sit here, but I actually had comments from other commissioners saying that's really a good testimony. I really understand that. And then the next person would get up and say something completely different, and I would go, and that's really good testimony, and that really makes me think. So developing consensus is not an easy thing here because there are so many different opinions, and many people are so incredibly prepared and are experts in their own right, okay, on this particular complicated process, that it's hard for someone like me, who's a lay person, right, to come to some conclusions. I do want to respond to Commissioner Sidley's comments about translation, because she and I have had considerable conversations about this as the subcommittee, and I happen to disagree with her. I think it's really important that, particularly as the economic justice issues and communities of economic justice are involved in this process, that one of the issues that puts people in a detrimental position is because of language change, because of the fact that they don't speak English, legalese and all of those kinds of things. I used to joke when I was in the legislature and say to Ledge Counsel, you know, I wanted to write it in English, and then you're going to turn it into legalese, but I still have to understand what it is in legalese, because it's a different language. And particularly under CEQA, right, where I don't understand half of the terms most of the people are talking about, to be honest with you. I just need some common sense kind of direction here as to what makes things work. And so my idea is, I hear what Jana is saying in regards to, are we going to translate thousands of pages? I don't think that that's what the suggestion is. I think that we could probably figure out, and whether or not in our recommendation, we have to go into such depth as to what the translation process should be, but at least there has to be something in regards to, you know, the major documents that can tell a community, right, who's not interested in reading the thousands of pages, right? They don't have the capacity, the interest, or whatever. They just want to know what the potential impacts might be on them, and that should be in languages and meeting the threshold languages, right? And there's already state law around that. Right, the threshold languages, the rules around threshold languages are already in statute. They've been there since the 1970s. I don't think we need to change them. I think we need to take them into consideration as we're looking at processing documents and providing communities with access, right, where they are comfortable in their own language. The issue of timeliness, right, is, I think, huge on everybody's side, right, in that there are impacts of these proposed developments, whatever they might be, okay, that are of direct concern to communities from different perspectives, right? But there has to be an end to the process. In the legislature, there's an end because the Constitution says, right, that you die, right, meaning, right, D-I-E, I think is how they spell it, actually the same way. At the end of 2-year session, you don't get to go any further, right? And you might win some, but there might be some things you just leave hanging, right? And it's frustrating. I'm a former member, and I would be so angry, right, if I had gone all the way, but hadn't had that final vote because the legislature timed out, right? And so there has to be some time certain, I think, for all parties, whatever that is, we can all argue about, but cases can't go on, right, and go on and on and on and on and on and on. That's not good for the communities that are involved, that have to stay involved, spending all of that kind of time, right? And it's not good for the proponents who want to do a project. It's not good for the environment, right? How long are you going to wait for a wind farm to be developed, right? We need them tomorrow, or we needed them last week, actually. That kind of thing. And so I think that there has to be a time certain when everybody gets their documents in, whatever that means, okay? And it stops then, the document input stops then, right? So that there can be a consideration and a decision made, so that communities can go forward one way or the other. I don't have any comment on attorney's fees, really. I understand what the issue is. I don't know what the answer is, because there is such a discrepancy in regard to people's capacity, right? To say to community-based organizations that you have to have a skin in the game. How much do you say to CBE or to any of the environmental organizations, right? That are run because people like me send them a check once a month, right? My $100, right? And so they collect a whole bunch of those. They can't, I don't know how they handle being responsible. On the other hand, there are litigants in these things, right? And I live in a community with lots of litigation. I happen to live in Berkeley, everybody. And a homeowner doesn't like something, right? Has considerable access to money, right? And maybe is filing a frivolous lawsuit because they don't like the design of the house next to them, or that, right? Or they might be cutting down some trees, right, or wherever, or keeping the trees, and other people want to have a view, that kind of thing. In that kind of litigation, it seems to me that somebody has to have a skin in the game. And so how we compromise on that to figure out who has capacity and who doesn't have capacity, right, in regards to attorney's fees, I think that that's an issue. The modeling, I gather what we're talking about when we're talking about modeling is what the project is. What's the defined project?
No,
okay,
modeling is what you're going to plug all the information into and run various.
Scenarios.
Yes.
Oh, okay, already. Then I don't want to make a comment on that because I'm not so sure I quite understand that one. So I think that's what I have to say right this minute.
Let me go down. Commissioner Hernandez, I believe that you're holding. Did we lose you? Are you in the tunnel? Are you muted? I can't
Commissioner
hear you.
Hernandez.
How about now? How about
There
now?
you go. Now you're back.
Sorry, just at the airport. On the translation, happy to discuss further. I think there's pros and cons, but I've written legislation requiring translation, and a lot of times there's unintended consequences. So I think that it does merit a follow-up discussion in terms of how to do it well. I mean, if we are talking about timeliness, I mean, it could be a double-edged sword, but at the same time, I definitely agree that we need to increase access to different communities. So happy to continue that conversation with commissioners if time permits. One thing that was brought up on attorney fees, I forgot to mention, I think this is related to intervener compensation, that I think maybe, yes, we do attorney fees, but have a way to offset those fees for certain communities, having a process to do that. And then there was a third piece that I forgot, but just reiterating that it would be good also as we list the recommendations to note which ones are higher priority than other ones.
All right, Commissioner Garcetti.
Thank you. I would support everything our Commissioner Breyer said, with one exception, and that is the courts. I believe there should be some specialized courts. And I'm glad that you, Commissioner Sidley, really pointed out the complex issue about translation, because I think that does take a separate deep dive with that, because I'm familiar with how long it takes to get death penalty cases to the Supreme Court. Years. And by years, I'm talking about 7, 8, 9 years before the real appellate process begins, because they can't do anything until they have the record in front of them. So if we do a deep dive, it has to be, what languages are we talking about and how much, and can we specify specifically what needs to be translated? So that's really the two of those. But going back to the specialized courts, I would go further. And I think we need to look at, if we're going to have statewide courts, and I think it has to be statewide courts, how many courts are we talking about? I believe the idea of having dedicated civil service research lawyers who specialize in CEQA is absolutely a necessity for the bench to do the job. I mean, this is overwhelming when they talk about 100,000 pages. And to do the job right, you can't speed read through these. You have to be taking notes as you go through it. It's almost incomprehensible to me that one person can or would be willing to do this. You can't last long in doing it. So I think any recommendations that we might make has to be very inclusive in terms of supporting the idea, the concept. And if you're going to have one judge or 50 judges handling this, they need built-in staffs that are dedicated, that when that judge leaves, that staff for the most part remains, so there's continuity and they can work with them to do it. Here we are.
Mr. Emerson, let's go down the line. All right.
Also, Mr. Chairman, just FYI, Commissioner Breyer has re-raised his hand.
All right, I'll get to you after Commissioner Emerson, David.
I still have PTSD dealing with this issue when I was in the legislature and with discussions with Governor Brown. Senator Cannell and I spent months and months with Governor Brown working in a bipartisan way to make some changes here. And I agree with some specialty issues, because this is a very specialized area of the law. I know we have some specialty courts on the federal level, and they seem to be working fine. So I agree with my colleague Gil Garcetti on that issue. And I also agree in general principle with what Commissioner Byer has said. So,
Commissioner Byer?
Sure. Well, thank you, Mr. Chair. A couple of suggestions about maybe splitting the difference. One on specialized courts versus improving the existing assignment of judges to CEQA cases. I think if we recommended that the legislature review the pros and cons of each with the eye towards facilitating development of improved outcomes, timeliness, and facilitating access. And we can list the pros and cons because they're already in the staff memo. And basically what we're doing is we're teeing up the question for the legislature, and it's going to have to be resolved by them. So I know it's weaker than calling for a specialized court, but I think that would be one possible compromise. On translations, I think if we limit the translations to something that facilitates access by particularly disadvantaged communities, and that is focusing on notice in plain language of what has been proposed and what the risks are, we can deal with the risks of expense and time delay. One key component, however, will be that the failure to do that correctly doesn't get to the stage where it creates satellite litigation about the competency of the translation and delaying further the CEQA case. So one option there might be to impose some kind of penalty, whether it's public scrutiny or some other financial penalty on the governmental agency if they fail to translate the notice of a public hearing or the notice of a summary of the EIR. Again, both of those questions, both the specialty court and translation, I think if we articulate the issues the legislature is going to have to grapple with, that may be the best way to reach a consensus and advance our report.
Thank you. Vice Chair Varner?
I just wanted to comment that, just in general, it's amazing to listen to my fellow commissioners and see the staff memo and how reasoned this is. And I think everybody has the right mission. And I agree with Commissioner Sidley and Commissioner Byer with their comments. I also think that a lot of what the staff has put together in conjunction with this subcommittee really does address some of the issues raised by the young folks that came here to testify for environmental justice, especially when you talk about things like pollution and there's a need, and Commissioner Aaroner did mention it, there's a need to expedite some of these initiatives, especially when it comes to climate change and various things we need. I mean, we need to review our entire electrical grid throughout the state to ensure that we can facilitate some of these concepts. But I just want to mention that, wow, it's just incredible to just to see what the staff has done and hear my fellow commissioners speak about this, because it's pretty special.
Yeah, well, thank you. Well, and once again, I think it's we've been very, very fortunate with the caliber of staff that we have with Little Hoover Commission. And again, following this template, with respect to CEQA courts, one of the ways to approach it might be to identify and suggest or require CEQA departments. I think the notion of a CEQA court is one of a standalone entity that is more likely than not going to generate hostility from the judicial branch. Those of us who have practiced in front of judges, I mean, every single judge believes that they are the only judge. And they don't like to be told what to do and how to do. They like to tell you what to do and how to do. So the notion of a department, for an example, in Los Angeles Superior Court, there is a complex litigation department over there on Constellation Avenue. Those judges are experienced. They deal with class action lawsuits and other matters of high complexity. And that seems to be an approach that was adopted by the court, and they like it. And the judges that go there are there because they are drawn to those kinds of cases. So the idea of a CEQA department where the staffing and budgeting is done in conjunction with the presiding judge of that location is more likely than not to be readily embraced as compared to the establishment of a separate CEQA court. So that's just one of the options. With respect to document translation, I am a firm believer that artificial intelligence is going to make this one of the easiest things to do. I sent an article to Ethan about an individual who used to work, I think it was at Microsoft, who then purchased a newspaper. And it was one of those community newspapers, and they lost reporters. And so as an experiment, what he did is he played a recording of a meeting through an AI. And he said the writing was somewhat clumsy. It would be like the equivalent of a first-year journalism student, but the story that came out was true to what had happened in the recording of that meeting. So I have a feeling, particularly with the accelerated pace of technology, that it is going to be relatively simple and inexpensive to take documents, put them through a scanner, dial the language that you want, and then you'll have a translation of that particular document. Now, as to the issue of liability for poor translations, it seems to me, and Dion, you really touched upon it, the standards for translation should be set by the legislature, so that if a city or a county purchases software that has been authorized by the state of California, then that provides them hold harmless, should there be any issues with translation. On attorney's fees, if we are going to look at attorney's fees, you really have to keep in mind that there are organizations that make it month to month. They don't have resources. There's no piggy bank that they're going to go back and pull money out of. And so if we want, because we talk about equity, there isn't any, there's very little equity when you are a community-based organization relying on bake sales, and there are many of them, as compared to a corporate home builder or a city or a county. So if you're going to talk, if we want to include a conversation about attorney's fees, I think it has to include a provision for court review of the parties as to the ability to pay. Shouldn't be any different than looking at the imposition of child support. If you can't pay it, then it's reduced. If the organizations that are involved in this have a lack of resources, they're already going to be thinking long and hard about whether or not they should become engaged. And if they think that they're going to be exposed to attorney's fees, which will mean the end of that entity, because it could mean the end of that entity. I mean, one of the approaches that the federal government has had with hate groups is suing them into oblivion and bankruptcy. I don't want to see that happen to community-based organizations who are articulating the position of environmental justice communities and fence line communities. On the administrative record, what I gathered from the testimony of witnesses, on the one hand, people are saying anecdotally, I mean, why do we have to look at emails that have, pizza order for lunch? I'm not so sure that that's what people are finding as they go through the administrative record. I think what people are finding as they go through the administrative record are conversations that in the light of day look like violations of the Brown Act, that looks like counting of votes, and it looks like predetermining an outcome. So I think we have to be conscientious. I don't think we should embrace the perspective that the only emails that are worthy of evaluation are the ones that are somehow weighted as being part of the ultimate decision. Because, I mean, there's a long and winding road of how local electeds are influenced. As as our esteemed Supreme Court has demonstrated for us only recently. Standing to sue, I do agree there's some merits with respect to standing to sue. I do believe that there have been abuses by individuals who are seeking to enhance aesthetic aspects of why they are opposed to a project as compared to having legitimate concerns. So standing, I have some reservations. I'm going to have to see the language that we end up developing. But I think as a conclusion to my sentiment, what I have come to appreciate that I did not understand before was how CEQA has evolved into a means for and by which dispossessed, impoverished, low-income communities have a footing and a platform from which to articulate potential harm to their communities. And even with that, you still see the sorts of circumstances that develop with warehouses in Fontana. I grew up in Fontana. I'm a Fontana High School graduate. And when you look at the placement of those warehouses, backyards abutting the bays where the trucks unload, and the increased incidence of asthma and other respiratory concerns, I just think that we've got to be extremely conscientious that we do not disenfranchise folks who have found a way to begin to express what it is that impacts the qualities of their life. And I am I'm very pleased that we have had this conversation as it relates to the role of the judiciary, because I do think that what we have seen is in other senses a mission creep, that there have been the expression by individuals in the judiciary as they see something that appeals to them that ought to be incorporated as a part of the review. And the harm of that is that it leads to the calls for wholesale change, which aren't merited. Again, those of us that have practiced in front of judges, we all know that they could be wearing Speedos under those robes, and we're never going to know, but they think they're entitled.
Chairman, I just want to make very clear, I appreciate all of your comments and I'm listening very intently. Not for a second am I trying to disenfranchise anybody. Not for a second.
Well, then we need to make sure that this report doesn't do it.
I don't think anybody ever intended for it. I think that what we're trying to do is, understand the complexity of CEQA and all of those that have come to testify on all sides. And I've heard your point and I appreciate your point. I just want to be very clear that not for a second do I want to disenfranchise anybody, but I also want to make sure that I'm not disenfranchising somebody who wants to maybe promote a project. I think everybody deserves a fair bite at the apple here.
Well, I don't know why you would think that that was in some way, shape, or form directed to you. It was certainly not my intent. I think that we all have to be conscious of unintended consequences. And right. And we do not want an unintended consequence of what we do here to get misinterpreted and then weaponized in a way that shuts off access to people who want to use the process.
Mr. Chairman, Commissioner Cannella raised his hand, and then after that, Commissioner Byer raised his hand.
Thank you, Mr. Chairman. Unfortunately, I'm getting my roof redone at my office, and they're right outside my window right now. So if it gets distracting, let me know, and I'll turn my mic off. But one thing I want to make sure, as far as attorney's fees, I'm a civil engineer and I work on projects, And there are folks that use CEQA as a way of personal gain. And so what they'll do is they'll sue, maybe there is an issue, and instead of dealing with that one issue, they'll throw everything, including the kitchen sink, at it, and it drags the challenge on for a long time, and then they incur and win attorney's fees. And so I think we do need to deal with the attorney's fees, just so let's focus on what the issue is. If it's traffic, deal with traffic. If it's, backyards abutting truck bays, let's deal with that. But when you throw everything at it, it drags the challenge on for a long time. And the folks that are doing it for personal gain get attorney's fees. So with that, they're hammering, so I'm going to shut up my mic.
All right, did you say something? Thank you. Someone else?
All right, Commissioner Byer, I believe, re-raised his
All right.
hand.
Commissioner Byer, before you speak, there was one thing I overlooked, and that had to do with the models. And I think one of the important aspects of the models is it does create a level of certainty. I do think as we have the conversation of the models, there ought to be a provision that allows for newly discovered science so that you can't ignore the science.
Well, that's a critical.
Well,
That's.
all right. So the issue, right. If the issue is, I just want to make sure that when we talk about the models, that if in the course of the process, there is a discovery with respect as an example, toxicity of a particular material that had not been considered, but their science supports it, I think it would be irresponsible to say that cannot be included because we didn't know about it 3 years ago. That's
Yeah, but Mr. Chairman.
All right. Thank you,
Yeah.
David. Yeah.
So I think you're making an excellent point about the models, which is why I suggested that the legislature be required to review the elements going into the environmental impact review on a set calendar basis for the exact reason that you specified. So if it's forever chemicals, which I wouldn't have known what they were 5 years ago, but they're a big deal. And now they should form a basis for concerns over lots of projects. So I agree with you. And if I could just offer a little bit of nuance on attorney's fees. I spent 10 years writing statutes about the federal courts and attorney's fees, and you're spot on in raising that as a legitimate concern. Fee shifting is controversial, and I'm only aiming at the state and local government participants in fee shifting. I'm not talking about developers or people who are doing projects and who have, plenty of money. What I worry about is the inadvertent pressure on those jurisdictions to approve things, because if they litigate them, it comes out of the state or local government budget. And so they go, well, let's just approve it and let the developer pay the defense costs or justify the project. That bias hurts people who are in disadvantaged communities. That's my exclusive concern.
Okay. Thank you. Yeah, you, please.
Regarding the fact that somehow the statute has to acknowledge science, right? God forbid we should actually acknowledge science and things based on fact and not somebody's rumor. But I am concerned about how it's not so much how we write this requirement, it's a question about how it gets handled in the legislature. I don't know, one part of government can't necessarily require other parts of government, right? We have a separation of powers here. And so I'd be interested in trying to figure out how we somehow encourage, right? This is kind of like the University of California, right? They have constitutional protections. How do you encourage the regions to do something when they get to do whatever they want? And the only way I ever figured it out was you withhold money, right? And say to them, and you sit here and bargain with them to say, you want this, well, we want that, because you cannot require the regions to do anything. They have constitutional protections. And so I'm just trying to figure out, and we obviously have time to do that, to discuss, to figure out how do we somehow encourage whatever the word is, the legislature take a look every whatever number of years it is, because as new science comes up, as things become clearer, right, regarding climate change and all of that, those might be very important things that need to be included in an EIR.
Right.
We're just recommending.
Yeah, well, what I hear the commissioners on the right side of the, my right side of the dais saying is that the recommendations will be articulated in such a way to provide direction and encouragement to the legislature that they figure out the way to do this. And so right. So, I mean, it is, if you control the budget for the judiciary, then part of that is the negotiations about what they want and what they get. All right. I'm fried. I want to thank my fellow commissioners.
Mr. Chairman, may I
Yep.
ask one procedural question from the staff standpoint? So we can take this feedback, and I would just note for members of the public or others that this is in no sense any final decision at all of the commission,
Right.
but we can take this feedback and at the staff and subcommittee level, try to develop more specific potential recommendations. Traditionally, the commission's process would have been that those would go through the subcommittee and there would be an actual draft report that would be approved by the subcommittee and come to the full commission. In this case, we have opened up this discussion today to the full commission because of commissioner requests. Does the commission wish us to come back with more specific and developed recommendation options to the full commission? Or does the commission wish us to work through the subcommittee process more in the traditional manner?
Well, what's the commission's pleasure? This is a bit of a break with the normal process, but I do think that this was the sort of topic that doesn't lend itself to the normal process, which was the subcommittee, which is what we did to get us here. So my own sense of it is that it probably should come back as a draft to the full commission, unless the subcommittee objects to it.
Yeah, draft report or sort of a menu of recommendation options to the, do you want us, in other words, we always traditionally would have come back eventually with a draft report to the full commission because it has to be approved by the full commission. My question is, do you want us to come back first to the full commission with something short of a draft report that is perhaps a set of recommendation options, a sort of menu based on the feedback we've heard today for the full commission to choose from?
Yep, you think? All right, it looks to me like they want the draft recommendations to be brought back to the full commission.
Okay.
Correct? Okay.
But I want to be sure that.
No, that doesn't preclude the subcommittee from doing, no, we will continue to work very much with the subcommittee and there is no issue there at all. So as the staff, we will continue to work with the subcommittee. That's not the issue. It's just whether or not we were going to wait to a final draft report stage to come back to the full commission. I think the answer is not. We will come back with a menu of potential options.
All right, glad you raised that question. Is that it? Have we? Okay, we've done it, I think. Let me again express my gratitude to fellow commissioners for the work that we did today. This is what you get when you start meeting in public. No more remote. And thank you to members of the public and those that participated in public comment remotely. Thank you all. See you soon. That concludes the meeting.
Thank you. Oh, well, that's up to the commission. Did you want to take up the issue on future topic selection or?
Anybody want to do that? All right, I tried to get you guys out. It didn't work. So back on the our meeting. We did not adjourn. We're back. We're back to the conversation about future.
Can I just make sure that Shara did not? If you can give us that information later after the meeting, perhaps. Actually, meeting is still underway. So Shara, we did not. We are still. It was okay. Fine.
All right,
Thank
very
you.
good. Thank you.
Okay.
So it's on. Your turn.
As the commissioners know, I might mention, by the way, that I asked Ashley to come up with me and help me take notes on that discussion because she has done a lot of assisted both me and Tristan in the CEQA research and has done a fabulous job. So I just want to note that. And please stay here while we talk about future topics. As commissioners know, there was a supplemental packet sent out yesterday on potential future topic selection. There's a because we sent it out late, we printed it out. It's at each of your places there. We will not be able to add because of staff bandwidth, we cannot add any additional topics right now. However, as Commission knows, Tristan's position is vacant. We're working now to fill that. However, Crystal is on a long-planned, lengthy vacation. She will return in mid-July, and at that point, I anticipate, probably, depending on how CEQA goes, that we will have some additional staff bandwidth to add one more topic at that time. The list of potential topics before you is essentially the list that you have seen previously, except that Commissioner Hernandez asked that we add a potential follow-up study on AI. That is listed at the top of page 3 in this packet. So I don't know if he's still on the call, but he could speak to that if he wishes. But he asked that we add the possibility of an AI follow-up. And then there are two. Okay, he is still here. And then there are 2 letters beginning on page 7 and page 9 that deal with legislative requests for studies, one on from Assemblymember Jackson on affordability, and one from a variety of legislators on retail theft. And I'll let those letters speak for themselves since you have them. So again, we wouldn't be able to add it to start work on another topic immediately, but we could add one, I think, and start work later this summer, or scope out potential topics, or whatever the commission wants us to do.
All right, let me just open it up to commissioners for their thoughts.
And I believe our Commissioner Hernandez and Commissioner Canella have both raised their hands on this issue, and Commissioner Byer as well. Oh, all 3 have raised their hands. Mr.
Okay.
Chairman. Hernandez, Canella,
All right,
Byer.
Hernandez, Camilla, and then Byer.
Commissioner Hernandez?
Hi, Richard. Can you hear me?
Yes.
Just to kind of better clarify that it is a follow-up on AI, but more on the future of work. And I think that the chairman gave a great example today when he was talking about AI and translation.
Okay. That's one. Let's go to Commissioner, was it Canella that was next?
Yes, thank you, Chairman. You know, I think on the Prop 47 letter from the legislators, I mean, any of us that have served in the legislature understand that to get that many Republicans and Democrats to sign a letter is very unusual. And I do think it's a topic that desperately needs to be studied on what's causing all these retail thefts. So I think that's something that we should absolutely add to the list, because again, the legislature and how they've come together, and also what we're seeing out in the public. So I would really like to see that topic be studied. Thank you.
Commissioner Byer.
First, I want to thank my fellow commissioner for proposing artificial intelligence. Having been involved in the 2018 report, I appreciate it. I viewed it as a compliment for the work that our former colleague, Commissioner Brigas did. But having said that, I agree with Commissioner Canella that retail theft is an important topic on its merits, but it's hard to ignore the impressive number of signatories on the letter. My only slight caveat is I don't think we should frame it as just Proposition 47, rather a more holistic view of the problem, because it may not be just connected to the change in law that resulted from that particular proposition. It could have to do with lots of other factors, and we just shouldn't ignore the other constituent parts that go into either causing or how we respond to retail theft problems.
All right. So let's hear commissioners that are present in the room. Any thoughts, what you've heard so far, or new topics? Sorry? Yeah.
Let's hear from the district attorney. Well, this is of particular interest to me, obviously, but I can't see how we can not do it, given the legislature it's not one, it's not two. I mean, we have dozens. who are asking us to do it. We have to do it. We should do it. It merits a study, period.
Don?
Yeah,
Mariner?
I agree, right. We've talked about this over the years, that when the legislature shows an interest actually and someone to put together this kind of signature list, right, is quite impressive. Is it an issue that I really wanted to put at the top of the list? I have to be honest with you, no. Given I live in the Bay Area, I'm not so sure I'm concerned about Chanel and, other high-end people, high-end stores, right? Even though they deserve the protection of the law just like everybody else. And so, but given the fact that it looks like a majority almost of the legislature has asked us to do something. But I appreciate, I think it was Mr. Oh, no, that's the whole point. They do. And so, right. And so, I just don't, the legislature is a partner with us, right? In regard that they are one of our audiences, right? And when the audience kind of says, here's what we'd like you to look at, I think you're right. We want to expand it. It's not just about Prop 47, because I think other things are driving this as well. So, but I don't think we have, and where we put it on our schedule, that's a whole other issue as to where we put it on our schedule, right? Because right now, as Ethan has pointed out, we are missing one staffer. And so I need to take into consideration other staffers, what their plans are, right?
Correct. Yeah, we
can't-
that we can work on
we
as
can
we go
figure it out,
forward in
right.
terms of fitting it in. And again, just to be clear, we cannot start work on this immediately. I can communicate that to the legislature, but
Right.
if it's the choice of the commission to add this topic, we will add it and work on it as we can. We also need to review our
The list, because there might be something.
the list and the CEQA situation. I need to review
Right.
how much staff bandwidth is going to be needed for that. So I don't think I don't think the commission should decide right now exactly when we add it to the hearing schedule or something. It's more just, is this the topic that you wish us to add as we are able to do so?
Yep. One else? So I think it's clear the commission's consensus is, we'll confirm our interest in the letter from the multiple legislators. And you'll let us know, or let them know too,
Yes.
about our staffing situation and when we might take it up.
Yes.
Right? Do we need to given that, do we need to give you another topic or assignment to pursue?
Well, the CEQA matter seems so simple and straightforward, Mr. Chairman.
You're
that
gonna have plenty of time
I think
tomorrow
we'll be
afternoon.
done in a day or two.
There you go. That's kind of what I expected.
By tomorrow.
All right, I think we've exhausted the conversation with respect to future projects. And so somebody tell me whether or not now I can adjourn. Yes, no? All right, fine. The meeting is adjourned. Thank you again.